Notice has been served, my lord. Copy has been served.
470?
474, my lord.
474.
Yes, my lord.
Okay.
Kindly take this matter, my lord, most urgent at any day at convenient time.
When the electricity connection was disconnected?
Disconnected, my lord, 1711.
1711. Why? You have not paid the amount?
No, I have paid the amount.
Ah,
Fact is this, they have made a complaint against me.
okay.
I surrendered before the court, got the bill, I have paid the money.
Ek kaam karo.
Similar matter, my lord. Similar matter, my lord.
All electricity matter be given. It may be listed on 11th of December.
11th of December.
Yes.
I'm grateful, my lord.
Grateful, my lord.
All electricity matter.
Grateful, my lord.
Lordship, I am permitted to what electricity matter, what they are telling with regard to disconnection, take 11 December as urgent motion.
My lord, one. Lord,
permitted to
serial
mention
number
in the
396
urgent matter.
Lordship,
Any electricity matter for
yes, Lordship, I have an excuse. Lordship, I have a withdraw this matter. Lordship.
Withdraw this matter.
Yes, Lordship.
Withdraw keep it on Monday. To be mentioned within bracket withdrawal.
Get.
Electricity matter is over.
This matter,
Electricity matter is
yes,
over.
Lordship, this matter, Lordship, 2nd December.
Once I am asking whether electricity matter is over or not.
No, Lordship, Lordship, electricity matter, Lordship.
You.
2nd December, it has been during the pendence of the writ petition, it has been disconnected.
Okay, it will come on 11th. It will come on 11th.
To other matters under
All electricity matter on 11th. Yes. And non-prosecution.
May Lord, may I?
Lordship,
May I?
serial number 396.
Yes, or non-prosecution. उसको कर देना. Monday application.
May I be permitted, my Lord?
Non-prosecution Monday application.
Serial number
May I be
396.
permitted to mention very urgent matter, my Lord?
For last 20
All or submit. I will see. Submit all.
ইলেকট্রিসিটি বলে দিলে আবার তুমি আরম্ভ করেছো কেন?
You were saying he is submitting. You are saying he is submitting. But both the persons are submitting. What the court will do?
ঠিক আছে।
You persons are senior persons. Yes.
serial number 396. I am in jail for last 26 years. I am 80 years old, a premature released, and he is the reformed inmate, and there is no adverse reporting. So this matter may be taken up.
So what is your prayer for premature release?
Yes, Lord.
What is the conviction? What is the sentence?
302 murder case.
Murder case.
Yes, Lord.
It is a life imprisonment.
Yes, Lord.
How many years he has suffered the
6 years.
6 years? So you made.
26 year.
So what the record will you made a request?
I have made the request. The representation has been discarded. So it has been. Lordship.
So what is the urgency?
Urgency is I am 80 years old, Lordship.
Huh?
I will die anytime.
How many
80 years old person.
30 years.
80.
80 years. When the conviction was held?
Long back, Lordship. 26 years ago.
26 years ago.
Yes.
So how many years you are in custody?
27 years.
27 years. Come go no. 16th of December urgent motion.
May I be permitted?
Why? What is the urgency? उसको लिस्ट में कर दो, मोशन में कर दो.
My Lord, may I be permitted to mention, my Lord, item number 210 of the monthly list. It is urgent because, my Lord, the private respondent encroaching the roadside PW land are running a welding factory beside my petrol pump. IOC is, my Lord, the Indian Oil Corporation objecting that should not be allowed to run this. Therefore, it is very urgent, my Lord. And when the similar matter order has been passed earlier.
16 को रखो. 16 urgent motion.
Lordship, I permitted to mention two matters. Lordship, both the matters, Lordship, are in your daily list as item number 344 and 360. Lordship.
Sir, কত বললেন স্যার? স্যার কত বললেন?
Are under judicial custody for over 20 years. Lordship. And above the age of 60. Lordship. The Lordship may kindly take up the matter as urgent.
वो लास्ट प्रीमेच्योर वाला कब रखा था? इससे पहले प्रीमेच्योर 16 को ना? 16 को रखो.
May I be allowed to mention? My groundnut processing unit has been shut down
under the instructions of the local BDO on the ground that I am violating the pollution norms. And even after I got the necessary certificate from the pollution control board that everything is all right, he did not allow me to do it. My livelihood is affected by that.
When you obtain the NOC?
I obtained the NOC before I started the unit.
No, subsequently, when
Subsequently-
your NOC was over,
No,
then-
it is continuing.
so how it,
Continuing, those processes have been placed before the BDO,
Hmm.
but still the BDO, at the behest of the private respondent who has got the similar units there,
Hmm.
has directed my unit to be shut down. My
Okay.
livelihood is affected.
16 तारीख को रखो 16 urgent motion.
My lord.
I've given a notice.
My lord, may I
Inform the next date.
My lord,
Yes.
One matter that is running in the list, 225 of the daily list.
Hmm.
A single person with two names working in government organization, single person with two names.
Who are you?
I am aspirant of another post where
So you are an aspirant of another post. One person is working in one name, two persons are working.
no,
Two-
one person with two names.
That's a one person, two name, and he is drawing the salary up to two posts. Good. So what you want? So what you want?
I want that an investigation be conducted. This is allegation.
So how you are being affected? Go to the public
No,
register.
I'm affected, my lord. Because
Okay.
of one post, I also the applicant.
18 September, 18 November, December.
my lord, may I kindly
Urgent
mention, my
motion,
lord,
urgent motion, और वो दोनों को न्यू मोशन में करो.
my lord, may I kindly mention, my lord, one matter, my lord, related to pension benefit, my lord, related to pension benefit,
Ah.
my lord, as the heirs of the, my lord, deceased, my lord, teacher has not been, my lord, decided, my lord, I have filed the writ petition before the lordship, my lord, pension benefit, my lord, I am not getting the pension benefit, my lord.
You're not getting pension. Why?
My lord, family pension.
Family pension. Why you're not getting the family
The,
pension?
the legal heir of the, my lord, deceased has not been decided by the
Huh?
authority. Legal heir,
Ah.
legal heirship.
Ah.
So I have made application before the honorable court.
Legal heirs have been objected.
No,
Who is claiming the family pension?
the legal heirs of the Milord deceased.
Legal heirs of the disease. What is the
But
difference?
the DI has not decided the same.
Ah.
Collector has not decided the same.
So go to succession certificate. What the writ court will do?
Lord, succession certificate because succession certificate of payment of Milord money if there is a like
Correct.
in bank or otherwise.
Correct.
It is related to Milord legal heir.
Only legal heirs you go to the authority.
Lord,
Or the house.
authority is not deciding.
Ah.
Sure, sir. As I Milord, I filed the petition, Milord.
उसको 18 को रखो. Urgent motion.
My lord, kindly allow me to mention a matter. My lord, there is a writ petition filed against the Reserve Bank of India, the LIC Housing Finance Limited, and the civil authorities for correction of the petitioner's civil records. My lord, the petitioner's employment is on hold for want of a civil score, a good civil score. My lord, this is for inclusion. The matter was returnable on 17th. It was mentioned
17th of December.
on 17th of November.
Ah.
It was
What you-
mentioned later on
What you want?
for inclusion. Obliged, ma'am.
This matter was mentioned earlier by the speaker of the maximum practitioners by the medical council on an allegation of illegal gratification for grant of recognition of a medical college. Milord, no hearing advocate, nothing is done. Milord, my name is removed. I was just slapped upon a letter saying that my name has been.
My lord,
16.
my lord, may I be permitted to mention the item number 367 of the monthly list. This is very urgent matter, my lord. It will take few times. The matter is how the NH, the National Highway is going to widening the NH 34. Respondents are trying to demolish the structural building. So my very urgent matter.
What is the urgency? There is the urgency. The public road is to be widened.
Maybe
You are
I
in the
will, like, I have
you are
not getting the. I have also not got the compensation amount.
You are
far
the
the-
recorded- you are the
yeah.
recorded owner.
Well,
You are the recorded owner of the property.
yes, my lord.
And your own property has been taken by the authority.
Authorities.
But
Yes, my.
not acquisition proceeding.
No.
19.
19, yes.
One new mission not included, my lord. It is
My lord.
24th November. What is it? Actually, it takes 7
petition was participate in the tender process. Process has been complete. We completed the work. NOC has been done. The money has not been paid.
That is no urgency. That will
Haven't it-
payment. No. Yes.
Lordship, may I mention one?
It is in the list.
Yes, it is on the list.
When the matter will.
Completion certificate also issued.
Correct.
For last 1 year.
You have urgency. Go to the civil suit.
Lordship, may I mentioning one new motion for inclusion, Lordship?
My lord, may I be permitted to mention one matter? This is a residuary matter, my lordship. The matter was filed in September, my lordship. Came in the daily supplementary list on 22nd September. Then thereafter, it is not coming to the daily supplementary list. My lordship, new motion for inclusion, my lordship.
New motion due to my court.
Lordship, item number 461.
New motion for inclusion in the list due to my court officer. It will be taken.
My lord, may I pray for upgradation, my lord? My lord.
Lordship, item number 461 of today's list, your lordship. Lordship, as per the resolution plan, my client has already paid to the bank a sum of rupees 11 crores and odd. Now, what has happened is they had earlier illegally issued an LOC that my client has already received from the bank the no dues certificate and all other documents, but the LOC is still lying. They are not removing that. They are not giving me any information with regard to that. Now, I cannot move. I cannot go to other states even to do business. I am staying in my home at under a tremendous threat of an unknown arrest. Now, this is the situation, your lordship. If the matter is taken up, only representation consideration maybe, or if the bank comes up and tells that they have removed the LOC, then the matter will be over, your lordship.
19 crore.
My lord, may
Much obliged, your lordship.
May I have your lordships kindly to mention this matter, my lord? It was mentioned once on the 18th of November, my lord. My lord had directed the matter to come as a adjourned motion, my lord. This has been sent back, remanded back by the Supreme Court for de novo consideration by the High Court, my lord.
Who is for the other side?
My lord, WBCTCL, West Bengal State.
काम करो उसको Monday to be mentioned.
It was
May I have your lordships?
Monday to be mentioned में रखो.
My lord,
My lord, Supreme Court or where you have a Supreme
I have
Monday.
I am praying for
Kindly, a new motion that.
Use the microphone. I can't hear you.
Lordship, there is some urgency in the matter. Lordship, there is an electric pole which has been
Yes.
there is an electric pole which has been installed just in front of my house, and the wires have also are running just in front of my house, and electricity has been affected. So, Lordship, there might
When the electric pole was erected.
Lordship is a new motion, and it was
When the electric pole was erected.
last week.
19.
my lord, may I pray for
Lordship,
upgradation, my lord.
Lordship, may I permit to the Refugee Liberation Commission Department has already issued the registered deed, but there is some major mistake in measurement. I have mentioned earlier, Lordship, file has come.
What the court will do with regard to the measurement? What the writ court will do?
No. I have made a representation. Let them to consider my representation, Lordship. Kindly give the date, Lordship. I have earlier mentioned and
New motion में रखो.
Lordship, may I permit it to mention for
New
restoration?
motion.
Lordship,
Yes.
for inclusion of the restoration.
रियली बोलते रहेगा.
already going to under the and continue to notice as we now we do not have remedy under the SRPC Act because they are violating. I am challenging both the property because they are
I mean, if the surface is, this court is not having determination.
Municipality Act passed SRPC property was and the municipality property also
Go to the surface act, take an order, surface act, then come before this court with regard to the MSME. How this court can decide with regard to the surface?
orders that are defined on. Clearly say, I do not have remedy under SRPC Act. The orders are defined upon this court.
But the surface has been initiated against you. Okay, you go and
May I have your lordships?
go before the court.
May I have your lordships kind leave to mention item number 254, your lordships, today's list, lordship. I'll only be seeking extension for filing affidavit in opposition, my lords. There's no urgency in the matter, my lords. There's no interim order.
See, 252, the matter is there. In the meantime, you
My lords,
file.
I'm
When the
only-
matter will be taken, I will not extend anything from
Only-
taking as a
Only seeking extension to file an affidavit.
Your lordship.
Till again a file for a
Application, my lord, the item is 292 of the daily that new motion filing. My lord, my client is suffering as the bank is charging incorrect EMIs from my bank account as they have not disbursed the whole loan amount.
20-second karo.
Lordship, may I permit?
20-second. It is in the list. It is in the list or not? Let the come on the list. You. उसको लिस्ट में लेके आओ न्यू मोशन में फिर वो मेंशन कर.
May I be permitted to mention WPA 1204 of 2022, my lord. My lord, this is a very deeply disturbing issue. It is the writ application is preferred against the State Bank of India, my lord. What happened was there was a cyber fraud to the tune of 14 lakhs taken away from the petitioner's account, my lord. Now that has happened through the YONO app. And why it happened was because there was RBI master direct circular directing the banks, all the banks, to take certain safeguards, my lord. The SBI has blatantly refused to do the same, and that is why this fraud has occurred, because they haven't followed the RBI master directions, my lord. Now, what happened is, while we were waiting, while the petitioner was waiting for adjudication of his grievances, my lord, he couldn't take it anymore and he committed suicide, my lord. Now his wife and son has already been substituted, my lord. Now it is pending for hearing.
What is the prayer?
My lord, for the refund of the 14 lakhs, my lord, that was taken away because of the folly of the bank.
So who will refund?
The SBI would do so, my lord.
It is a cyber fraud. How the SBI can? It has to inquire. Matter is to be inquired into.
Yes, my lord, but I am
Whether
on the
any
point
criminal case is initiated.
my lord, criminal case has been initiated. Nothing has happened so far.
Then
My
what?
lord, I am on the point that this fraud wouldn't have happened in the first place had they followed the RBI master directions. That is why, my lord. If you're, I've got 5 minutes, my lord, I will satisfy your lordship what has happened actually.
Yes.
May I permit permission for inclusion?
One matter. I obtained loan
Oh,
in
yeah.
2014 and under Common scheme, I have paid all the dues not according to direction of the bank. When I went to return my original documents of my link, my lord, they refused to return my.
Why?
Why, my lord? No. You have to pay.
Which bank? Which bank?
SBI, State Bank of India.
Hmm.
Only return of my original documents.
Hmm.
My lord, I have paid all the dues, but they have given certificate to me.
22 तारीख को.
They have given certificate.
22nd urgent.
My lord, matter for correction, my lord. Just a typographical error, my lord.
Okay. परसों रखो. Monday रखो. Correction to be mentioned.
Lordship, application restoration.
Seeking leave for suspension of e-filing. This is the election petition for release of EVM machines for the upcoming elections in Hooghly district. The entire affected EVM and good EVM machines were kept together. So the affected had to be segregated and the good ones had to be released, your lordship.
Which matter? In which matter?
Your lordship, this is an election petition.
An election petition of before this court.
Your lordship, under residuary, your lordship.
Residuary. The election petition is pending before which court?
It's pending before this honorable court, not assigned to any bench.
Election. This court is having only one election matter.
It's not a signed matter.
No. If it is the election, what is the number of the election petition?
4 of 24.
So see which court is having this.
It has not been assigned to any bench. The original side matter, your lordship.
After filing, it has not been assigned.
Not been assigned.
So if not been assigned, so there will be no direction for the keeping the EVM.
Was direction passed by the previous bench.
That's why which bench?
It was passed by the Honorable Justice. Moshumi Bhattacharya.
That subsequently when it
It will be under residuary, your lordship. I'm seeking only leave for dispensing
No,
of
it is
e-filing.
but it is in the list of this court. I don't know because election matter cannot come directly. It is to be assigned by the chief justice to the concerned court, not directly, or it will go to the. I don't know.
Your lordship, only leave may be granted, then I'll satisfy your lordship. And leave.
What leave, man?
Leave for e-filing this.
But if it is not jurisdiction, how the leave can be granted? First, you check from the office in which court it is pending. Please see if it is before this court.
Then
I
I'll
will.
come back at 3 p.m.
Lordship, may I permit to mention for restoration, Lordship?
For inclusion, my lord. For inclusion.
For inclusion of restoration application, Lordship. Lordship, I'm praying for inclusion this restoration application.
Inclusion, you give all the things.
Restoration.
But in spite of that, Panchayat authority is trying to
not encroach the property by making for the purpose of making widen road.
Go to the authority.
Huh?
Go to the subdivision officer.
Without acquisition proceeding, we have we have made the representations. Nothing has been done.
Okay,
Your
उसको
Lordship, may I
19th में रखो अर्जेंट 19th.
Lordship, may I be
Your Lordship, may I be
Great to tell.
हाँ हाँ हाँ
বলবে তুমি
हाँ हाँ
তোমার
हाँ
দুটো আছে বেশিক্ষণ লাগবে পরে দিয়ে আচ্ছা কম দেখি ওয়েট ওয়াচ করি ওনার পর
2nd January. Okay, you file it. It will come by the time.
mention Lordship.
মাছের বাজার
उसको रखा ना 17 को ना 18 को प्रीमैच्योर रिलीज वाला मैटर्स कब रखा 16 को नहीं
বল বল বল
17 या 18 को रखा है
বল ঠিক আছে বলো বল
17 उसको रख उसको भी उसी में रखो
May I be permitted to mention matters which is 306 and 319 of your daily? It's a remission matter, Your Lordship. The urgency is that the accused has been in custody for over 40 years, one, and another one is over for 20. And they have been in condition for jail for this long period, and they have been.
so why you not requested the authority for release
You have requested your.
any decision has been taken by the jail authority
Yes, Your Lordship, we have requested them, but it has not been released, and also they are suffering from ailments and serious.
correct have you made a representation to the jail authority whether your matter been placed before the remission the committee
The report is rejected, has not been done anything with regard to that.
my lord
20 seconds
May I be permitted to mention, Lordship, item number 382 of today's list. Lordship, the passport authority has already issued a file closure alert till 24th December. Kindly fix a date, Lordship.
for
Urgency is that the petitioner's daughter's passport is lying with the passport authority. They are not releasing.
19 को रखो 19
मतलब in a complaint circumstances my lord
yes he's submitting again you are submitting
in the complaint circumstances I mentioned one matter my lord that matter I was served as a bona fide tender my lord notice in the year 2021 election my lord till date my lord no disbursement has been done my lord I am a my lord bank seeker my lord kindly take it up any date my lord as a urgent motion
22 तारीख
deeply obliged
My lord, may I be permitted to mention, my lord, item number 415 of today's list before your lordship, my lord. My lord, the urgency is that my
4 and 5
4155.
450
My lord, the urgency is that my lord, I have been recommended to receive the certificate of practice to act as a notary in the year 2024 by the concerned department of the state government. And my lord, for the said purpose, the prescribed fees of rupees 2,000 has been received by the concerned department in the month of July 2024. But my lord, till date, the certificate has not issued in spite of my lord several requests and written representation. And my lord, for this reason, my lord, I can't start my practice as a notary.
उसको 18th को रखो
Your Lordship, may I be
18th
Your Lord,
My lord, the date.
Your Lordship, may I be Your
item number item no 384 387 387 counsel for the petitioner mention the matter and handed over the copy of the order passed by the coordinating bench dated 19 November 2025 wherein the writ petition number 23704 of 2025 within bracket Ratin Shah RATHI Ratin Shah versus State of West Bengal and others is dismissed. Accordingly, department is directed to delete The case being WPA 23704 of 2020 from the first list. Yes.
Your Lordship, may I be permitted to one matter for upgradation that is running in the list, today's list 217. Your Lordship, urgency is that private respondents are threatening to the petitioner and they have raised unauthorized construction and they are doing several other illegal activities. Your Lordship.
20 seconds.
Obliged, Your Lordship.
Dispose of under inclusion why?
My lord, the honorable division being remanded back the matter, my lord.
You are having the division bench order?
No, my lord.
Okay, I am fixing on Monday, Tuesday as to be mentioned. Bring the division bench order, then I will fix the date.
Yes, my lord.
Where is the number?
My lord, I have.
Tuesday to be mentioned for bringing the order from the for placing the order of the honorable division bench. Yes, call the list.
May I please be allowed to mention a matter?
One very urgent matter. But this matter was running in the list of Justice Amrita Sinha till 31st of October. Now, there is a dispute regarding passport of the petitioner. Now, suddenly the matter, after the change of determination, the matter has gone missing from
What is the number?
This is the petition which was running fairly at the top of the list.
16th ko.
16th. I'm grateful.
16th ko.
My lord, may I kindly be allowed to mention a matter, my lord? I'm a senior citizen. I'm literally being driven out by 2 sons and daughter-in-laws.
Go to the authority.
My
Have you
lord,
filed an application before the SDO under the Maintenance and Welfare Act?
My lord, the house has been registered by me, but it has not yet been. It has been mutated till I'm being driven out by.
The authority file an application and they.
And I have filed civil representations before them.
Okay, 19 karo.
My lord, petitioner
in urgent motion.
Petitioner's salary was deducted on a certificate case, my lord. Petitioner's salary was deducted on a certificate case. Petitioner got a loan. That is why entire salary was deducted by certificate case.
Certificate case? What certificate case?
Certificate case, my lord.
I don't understand what is certificate case.
My lord, petitioner got a loan from a bank. Thereafter, petitioner is a teacher. And district magistrate and treasury officer deducted the entire amount from petitioner.
Okay. Yes.
My lord, kindly.
Yes.
This is a senior citizen. The application is due to early hearing of the petition. This is pending since 20.
What is the prayer in the writ petition? What is the prayer in the writ petition? What is the urgency?
Urgency is due to about 5 years have passed. No hearing has been done.
What you have prayed for in the writ application, sir? What is your prayer in the writ application?
Prayer is the property, regarding property which has been occupied.
It is not in the list.
No, sir.
Yes, call the list. Jalpaiguri ka Khalkar.
But this is my application. But here, an arbitrary order was passed by the state GST authority, and they have detained my goods, which are perishable in nature. That is the reason I have come up before your lordship. Now, on the two ground which the SGST authority has given.
This court is having determination.
But yes, because I am challenging the detention of my goods.
Where is that?
Yes.
Where is the order?
Your lordship will find in page 34.
34?
Yes.
32 and 34. Have you served copy?
Yes. Yes. This is affidavit of service is there, my lord. But although I am claiming the goods, they have considered my representation and now they have invoked 139(1)(2), which is not applicable. 139(1)(2) will be applicable when the owner is not there. But if the owner is there, my lord, then 139(1)(a) is applicable. That is the arbitrariness of the order. This is number one, and by that order, my lord, they have detained all my goods, which are perishable in nature.
So that's why, but you have to go to the. This court is can't take the matter.
My lord,
Tax matter, this category.
But this is not tax matter. This is relating to penalty only.
Penalty might
Yes.
be penalty, but it has to consider by the.
But my lord, arbitrariness, why I am challenging it? My goods has been detained on two score. They are saying the geographical my lord, location of the truck is not there. So our High Court judgment is there, my lord, when there is a my lord, the UA bill and tax channel, then that will prevail, not the my lord, the geographical location which is given by the authority.
That's correct. That's correct. But I don't think this court is see to that. I don't think that the determination is with the court.
Huh? My lord, kindly
This
see.
court is not having.
Monthly list, my lord, kindly see it.
Yes,
once.
yes. This court is not having. It is not coming under the group 9.
My lord, detention itself will come.
Detention, but consequence of the tax.
No, this is there. No tax. No tax has been computed here.
So why detention?
Detention because my lord, kindly see 129 months, my lord.
Page.
My lord, 120, but my lord, the act.
Section 129.
Section 129.
This is nothing to do.
My lord, this is nothing to do with the tax. Detention, seizure, and release of goods.
No, why?
When the conveyance in transit.
Yes, your lordship can please go.
129. My lord, kindly see 129. 1. Notwithstanding anything contained in this act where any person transport any goods or stores any goods while they are in transit in contravention of the provision of the act or the rules thereunder, all such goods and conveyance used as a means of transport for carrying the goods and documents relating to the goods and conveyance shall be liable to detention or seizure, and detention or seizure shall be released. But kindly see it once on payment of penalty equal to 200% of the tax payable on such goods.
Correct.
In exempted goods on payment of so and so, we are not exempted goods, whichever is less, where the owner of the goods come forward for the payment of such penalty. But here we have come forward, but they have invoked 129(2)(1)(b).
Where is the order?
Yes. Now, kindly see it. They have considered my representation, saying that I am not the owner of the goods.
No, they have considered my representation. They have dealt with my submission. Then this is a tax.
Page 35, kindly see 36. Submission.
Yes, yes. Page number 39. Page number 39. In view of
Now, kindly see page 39.
last part.
Last para B in paragraph 2 in his reply.
In view of the submission. In view of the above.
So they have considered it. In view of the above submission is not accepted. In paragraph 2, the reply is the following. We have given a detailed reply. Now they are saying, I am claiming the goods. They are saying, no, I am not the owner.
Paragraph 3, page 41. In paragraph 2, reply, he made the submissions, no intention to wait. They have dealt with my submissions extensively.
But the authority has dealt with my submission, in the order itself, and then come to a conclusion, imposing 129(1)(b), which is not applicable. 129(1)(b) will be applicable when the owner of the good is not there before the authority.
Yes, kindly come to the page 43.
43.
No objection has been raised.
Yes.
The valuation of the goods, or valuation of sensation, and penalty imposed in the notice is hereby confirmed. And
One calculation, kindly see in clause B of section 1. That is applicable when the owner is not there. Kindly see the act once, Here they have dealt with my representation extensively.
Here the facts, it is clear the actual supplier of the good is not.
Yes.
Tamara.
How they cannot come to a conclusion. My representation they have considered. And there are EOA bill and tax invoice to that effect. They have never disputed these are fake.
Where is that?
Yes, kindly see it. Page 24. Everything is there. EOA bill, tax invoice, everything.
25 is my EOA bill.
25 is my EOA bill and 24 is the tax invoice. 24 is the tax invoice.
24 is the
tax invoice. I have paid the tax. Kindly see. 5% tax was paid. Total amount of rupees 43,65,900. 5% tax 2,18,295 I have paid.
What is the item?
Betel nuts, dried betel nuts. Ericanut, sorry.
Yes, then
And 25 is the UA bill. Our High Court consistently saying when there is UA bill and tax channel, that is the concrete proof. The authority cannot go on the basis of a geographical location. That is the constant view of our High Court.
As recent as 25.
I am undertook to give a bond. Let my good be released.
where this document, in which portion this document have been considered?
Yes, kindly see my representation. My reply which I have given before them, here, page 32, 32.
First point, nature of goods and documents were in order.
Nature, goods and documents were in order. Now, goods under movement, dry Derricana, duly accompanied by valid tax invoice, UA bill, transport document, workmanship, everything we have given. Then I have difference of weight because we have said that this material, the product was procured from a remote place. Your lordships know these are forest product. So remote place we have obtained this and we have loaded it. Then it was on transit. Now they have detained it in Jalpaiguri. Everything was given.
And RFID cannot be sold to
What is the penalty amount? 39 lakhs.
No, 39 lakhs. Now kindly see the penalty amount which they have given. Page 43. 39 lakhs into 2.
79
when the owner is not there, this penalty will be imposed. When the owner is there, the original tax, which is 2,18,000, into 2. So total 4 lakhs amounts has to be deposited. That is in terms of 129(1)(a). Kindly see it. On payment of penalty equal to 200%. 200% it means into 2.
Correct.
Of the tax payable on such good. That is in 5% into 200.
Correct.
So 5% into 200, it comes about almost 4 lakhs something. That is the amount which is supposed to be imposed by them. But this is completely arbitrary order.
How they have calculated this?
They have calculated that I am not a owner of the goods in terms of 1B. 1B. Kindly see, on payment of penalty equal to 50% of the value of the goods. Got it?
Yes, yes.
Or 200% of the tax payable on such good, whichever is higher. And we are not in exempted good where the owner of the good does not come forward for payments of such penalty. Got it? The last part?
Yes, yes. Yes, who is for the other side? Who is appearing? Nobody.
No, but you have served. Affidavit of service is there. Kindly see. We are ready to execute a bond of 5 lakh rupees. Your lordship calculate it. It's 2,36,000, 2,18,000 and 2,18,000. Total 4.5 lakhs.
2,18,000 into 2.
Into 2. 4.5 lakhs at best.
Where from your
prayer?
Transporting.
From Assam to Delhi. Your lordship will get that in 24, page 24. We have a valid GSTN number. This was never under challenge. And last month also we have paid it. Kindly see. This document, the last month. Last month document.
Page number 54.
Now see page 54. Once. Last month also, for the month of October, November, we have paid the money. Page 54. October. And this was accepted by the GST authority. We are doing this business on regular basis. This is not a case that the first time we are doing this.
Where the vehicle was intercepted?
In Jalpaiguri. That is the route. Your lordships knows better than us. From Assam via Jalpaiguri, then it will go from Bihar, then Delhi. This is the destination.
Yes, recorded. The petitioner has filed the present writ application challenging the order passed by the deputy. No, I don't think this court is having. You give the determination list?
Yes.
So bolo determination bolo.
Well, it is almost like the other act, like PMLA, like NDPS. When there is the adjudicating authority, your lordship can remember, if they invoke any penalty, then the writ will lie before your lordship only.
But order passed by the GST authority, kindly come to the
detention of the goods, not for any
not
tax.
detention, but payment of the penalty.
No, penalty will not come, my lord. The tax, only the tax parts will come.
That the court will decide that, not by this court, sir. Please.
Well,
This, though the petition has argued the matter at length, but after going to the record, this court find that this court is not having the determination to hear the present application. Accordingly, the writ petition number 2422 of 2025 is released from the list of this court with the liberty to mention before the.
But kindly give me liberty to, my lord.
Liberty to mention before the. Court. Yes. Next.
Lordship.
I appeal for the respondent bank, मतलब
वो क्यों बैठो उसको अनाउंस करने दो आप फाइल दो जल्दी होगा. Yes, who is for the petitioner?
Lordship, I'm for the petitioner. This is that Aadhaar issue matter.
Yes.
Where the identity was, it's an identity theft
Yes,
issue.
got the CD.
Lordship. Lordship, before your lordship goes through the records, the state,
report has been.
the state is not just representing the police, it has also got to produce a report with regard to Directorate of Registration. That is where the same set of Aadhaar and PAN has been used. But no verification has been made with the UIDAI. And my lord, the Union of India is curiously absent again, where they have to answer for the banking ombudsman and the Reserve Bank of India. And because the XML and the UIDAI department also, for the process of verification, which is applicable to all PSU banks.
Have you gone through the report which you submitted?
My lord.
Yes. What is mentioned?
My lord, from what I could
kindly come to the page 2 of the report which you submitted.
May I have a copy?
Give the copy. Kindly come to the page 2, last paragraph.
During the investigation, the current
bank. What was the direction earlier? Where is when the incident was occurred?
In 2023, my lord, I had informed them. My lord, the
You show me the CD on 2023. Who was the manager and what is the statement of the manager?
My
Show me
lord,
the CD.
this is where I am at, my lord. I had called the investigation officer to my chamber, my lord. Yesterday evening, he had come. He is not available for 3-4 days now.
I had specifically asked him about interrogation of the bank manager, and at that point of time, he has stated, my lord, that notices have been issued to one Shubhodip Chandra and one Tapan Chandra.
Who are
is
they?
The chief manager and the bank manager.
When
under
the
section
notice was issued?
179 of the PNC.
When the notice was issued?
My lord, the notice was issued signed from the case diary. I have a, my lord, may I submit a photocopy of the case diary that is paginated? It would
Yes.
My lord, there's one submission with regard to the report. The report is also inadequate because there are 3 complaints.
Either you come sit here and decide the matter,
My lord,
and I will go there and I will argue on your behalf.
I apologize, Lordship.
My lord, kindly comes to page 21.
Yes.
Notice was issued, my lord, on 26th August 2025 to my lord Shubhayan Chandra, who is the chief manager. He has responded by email on 2020 at page 25. He has stated, my lord, that the bank officials verify the documents, prepare the report and give it in the system for his sanctioning, and if he finds the report to be everything to be in order, he sanctions the loan. That is his only limited role, and he has also.
That's why I am asking you whether on the basis of the email you are investigating, whether this will be evidence during the trial.
It cannot be.
Then,
my lord, they have to be interrogated. I
then
have told the investigation officer, my lord, they have not done.
Call the investigating officer before this court.
My lord, he may.
I immediately I will suspend him. The another investigating not below the rank of the ACP will be appointed. This is the way.
It should have been done. It has not been done, and this Shubhodip Chandra has also not appeared before the investigation.
Then.
Also, my lord,
and where is the document of Caesar of the document with regard to the sanction of the loan, and whether the handwriting of this petitioner and the document on the basis of which the loan was sanctioned, whether that has been compared by the through the GEQD.
My lord, may the investigating officer appear before my lord. On
Why you persons are accepting the brief if you have not taken all these things? Your case is that. His case is that he has not applied. His document has been used by some other persons, and the bank official has released the loan. Bank officer is stating that whatever the document you collected, you released the you sanctioned the loan. Now, whether his signature, because document speaks the signature, maybe the identity card is mine. Whether the signature is mine or not.
Yes.
This is a simple thing. The investigation is to be carried out within 2 days. And your GQD is in the Calcutta itself. It is not, it has to be sent to the foreign.
I had called him, my lord, and this is what has been. He is not.
When the investigating officer will present, you tell me.
My lord,
ask him.
Out of town for a
Wednesday, I'm not there.
Let here come tomorrow. Maybe a personal matter. This is the urgent matter of the court.
I called him. I asked him to come today only. My lord, he is gone somewhere. My lord, he is not in Calcutta. He will be returning on Monday or Tuesday. My lord, kindly keeps it on Wednesday.
May I have a copy of it?
Yes.
Lordship, not on Wednesday. I will be going to Delhi. My lord, on Thursday, next Thursday, 11th.
Landed Council appearing for the state has produced this case diary. After going through the case diary, this court found that the investigating officer, instead of interrogating the bank manager and the officials who were present when the loan was sanctioned, but only he has sent a notice, and the earlier manager has sent the reply through email. But the investigating officer has not made any endeavor for examination of the officials, including the bank manager who were present when the loan was sanctioned. Accordingly, this court finds that the presence of the investigating officer before this court is very much necessary. Let the matter appear on 11th.
11th, Lordship.
11th under the same heading.
Grateful to
at the top.
I'm grateful, Lordship. And my lord, I apologize again for interrupting this.
It's an
The report filed by the state be kept in the.
Lord, may I have the original case diary?
Yes, original case diary वापस कर दो. Original case diary. Original case diary brought by the state be returned to the learned advocate appearing for the state.
Wait,
Original case diary is returned to the learned advocate for the state. Yes, next.
In this matter, I appear for the petitioner.
Yes.
It's an application for restoration.
Yes. When the matter was dismissed.
Dismissed on 19th September 2025. The application has been affirmed on 22nd September 2020.
What is a repetition?
Not repetition, my lord. This is a peculiar fact. Not the appellate authority under section 19(1) of the Right to Information Act has passed an order which has not been complied with by the subordinate officer.
When you applied for the Right to Information Act, before whom?
Before the DL and RO. May I kindly turn to page 34.
So he has not supplied that.
PLRO has not complied with the order.
No, he has not supplied the document.
No.
Then you preferred an appeal.
Appeal.
Where is the appeal order?
My lord, the appeal order, page 34. Kindly seize.
Page 34.
Page 34.
Now the person I am observing reply of BLR is uncalled for. I will direct the BLR and I want to constitute a search team to trace all the record or the record information. If not Yes, then
my lord, kindly turns to page 36.
Yes.
This is the demand justice. My lord, the order was communicated by the office memorandum, page 35. Then my lord, page 36, this is the demand justice. No answer till date.
Yes, sir. You are appearing.
Well, I have to take instruction, my lord, of what was the position. It is, my lord, found from the record, my lord, the desired miscase is not traceable, but the searching process is going on. The DLRO, my lord, is finding, my lord.
2023 order was passed by the appellate authority.
Yes, my lord.
We are on 2025. If your PLRO will not able to search it out, let he come before this court. I will give the idea how it is to be searched it out. Otherwise, how the PLO is to be tackled, this
My
court
lord,
knows.
my lord is rightly said, my lord. He has said, my lord, I do hereby direct the bearer to constitute a search team to trace out the record and provide points record such and
If
such.
your PLO is more above than the appellate authority,
My
then
lord,
the court has to see.
kindly give me some time, my lord, whether this record has been traced out or not. What is the latest position?
The
I come
petitioner has filed the present application being CAN 1 of 2020. Number 2025. Praying for recalling of the order dated 19 September 2025, wherein the writ petition was dismissed for default for non-appearance of the petitioner. Full stop. At the counsel for the respective parties, this court finds a sufficient reason as shown on this court finds that the writ petition was dismissed on 19 September 2025 and immediately on 22nd of September 2025 the petitioner has filed the present application for recalling of the order. So the submission made by the for the parties per that sufficient cause has been shown for non-appearance of the petitioner. Accordingly, order dated 19 September 2025 is recalled. W10 number 1 of 2025 is disposed of. Full list of the WPA 15120 of 2023 restored. It is in its original file. Full list. This court find that in the present date application, the petitioner has prayed for a direction upon the BL and LRO to comply with the order passed by the first appellate authority, that is the additional district magistrate and district land and land reform officer, Paschim Midnipur, dated 22nd of February 2023. Learned counsel for the state prays for time to take instruction and to file report. Accordingly, the state respondent is directed to file report by way of an affidavit by by 12th of December 2025, after serving the copy to the learned counsel for the petitioner.
What was it?
The petition.
My lord, some time to be given, my lord.
But since 2023, I am waiting.
Okay, 15th of December 2025. Exception, if any, by 18th of December 2025. List the matter on 19th of December under the heading adjournment.
Grateful to you. No, under the heading listed motion.
Adjourn motion.
Adjourn motion. Grateful to you.
Urgent motion.
Urgent motion.
Yes, next.
And I am for the petition.
Yes.
I am for the petition. This is with regard to my alert, non-refunding my fixed deposit by the bank.
Fixed deposit?
By the bank.
Why? How you? It is a invocation of the any tender document, tender. Fixed deposit of your own.
Yes.
Why?
Of my own. That is the bank.
I am appealing for the bank lordship.
What is the amount of the fixed
But
deposit?
amount is 8,18,479.
When is the maturity date?
Maturity date was 30th December 2022.
Over.
Till
date it has not been.
No.
Why?
I don't know. You will also kindly come to this read petition. I will tell one.
Yes. Have you instruction?
Lordship. This is a matter, lordship, in which lordship evidence have already been exchanged. It is ready for hearing today. Lordship, my condition is that there has been some false statements made in the writ petition, lordship, as well as suppression of necessary
Leave
facts.
aside the writ petition false statement.
Lordship.
You admit that he
Yes.
is having the fixed deposit
Yes.
that
And
has
that
been
was
matured.
Yes, that has
But
matured.
why you have not released?
Why? The bank is withholding.
That is the only question.
Yes, lordship. The reason is, lordship, this matter has checkered history. Lordship, what he has not submitted as yet before the lordship, that he had a loan that had defaulted, it had become NPA, non-performing asset. The bank was constrained to file an original application before the DRT. A certificate was issued, sale certificate was confirmed, sale deed was registered. The mortgage property was sold to the auction purchaser. The very auction purchaser went to get possession, lordship, and there, what happened, lordship, the borrower, through his sister-in-law, had obstructed him in taking possession. And that auction purchaser was subsequently constrained to file a civil suit against him, against the bank, making all the parties. And that is still pending. There is an injunction order in that.
What is the injunction order?
Lordship,
Regarding property only.
regarding
not
the property,
fixed
not to
deposit.
create any obstruction, lordship, not to create any obstruction.
Correct.
Now, lordship, during the settlement process, lordship, when he had paid up the amount, lordship, after sale, he had said that he will not disturb possession of the property. He will not create any obstruction in the property, lordship. May I come only to the OTS terms, lordship, is at page 74 of the writ petition. Lordship, point number 6, borrower to submit unconditional undertaking while accepting the sanction of compromise offer that they will withdraw all the legal securitization application / other cases at various forums not known to the bank, against the bank or any of its officials, and they will not file any claim against the bank. Lordship,
I have not filed any case.
true. In literal lordship interpretation, I do not stand a case here. But lordship, he's admitted, lordship, I have made that submission in my opposition. He has filed his reply. He has not denied that allegation, lordship.
What?
That allegation, lordship, that he is still continuing to disturb possession of the auction purchaser.
Whatever it may be.
Lordship.
He has obtained loan, become NPA.
Lordship.
He has started the surface, whatever it
Lordship.
may be. Then thereafter a settlement was there.
Lordship.
His property has been sold it out.
Sold off, yes.
The sale certificate has been issued.
True.
Correct.
True.
So that loan is over.
And not only, no, sorry.
Loan amount is over. Now the question is with regard to giving the possession to the person who have purchased the property.
Lordship.
So he has not given the possession, or he has put his sister in the possession of the property.
Yes.
And subsequently
There is a
they
bank's
filed-
contention. Yes, Lord.
there is a filed case. In
Yes.
that case, they obtain the injunction order, and the bank is also a party.
Lordship.
You show me how you can retain the fixed deposit. That is the only question.
That is the only question, lordship.
This court is not go to the with regard to the civil suit, that the civil suit will decide whether he is liable
No.
to pay further amount, is not liable to pay further amount, whether this condition has been violated or not?
Like, Your Honor,
Whether you can show me.
I cannot improve my case, Lordship, in that regard, Lordship, because only what I am submitting, Lordship, that he had to cooperate with the bank. He could not have, Your Honor, curtailed the rights of the auction purchaser there, because the bank has sold off the property to him on as his rights basis. He was satisfied with the possession, but after taking possession, Lordship, these things have surfaced.
But how you can retain that? You go and fight.
But
you recall your OTS.
he has also failed to come up with a clean history, Lordship.
You recall your OTS, whatever it may be. How you can keep this?
Lordship may only indicate one line, Lordship, that he will cooperate with the bank in clearing of the title. That's the only that's true, Lordship. Whatever has fallen from, Lordship, is true, entirely true, Lordship. The bank only wants, Lordship, that property should be he should not curtail, Lordship. He should not create any further disturbance.
Page 56, what is the sales certificate they have issued, to whom they have sold it my property, free from all income.
Yes, I am saying so. It was free from all income. Thereafter, Lordship, thereafter.
They have handed over the possession to the person who has given, to whom he has given the, why he is saying that I have put all this thing?
Thereafter, after the sale was confirmed, Lordship, he has inducted that person.
How can I?
That
they have taken the possession.
That your client knows better, Lordship. That his own client knows better.
Very surprising.
Who is in possession of the property?
I am not in a position. I don't know.
Who filed the suit? Who filed the suit?
The
auction
purchaser.
It should not against me, against the bank, against the third person. I have been made a defendant, not the prelim.
And Lordship, in my opposition, I have stated those facts, Lordship. That has not been denied by him in his reply.
I have denied everything.
Which paragraph? Which paragraph?
Paragraph I have not denied.
Article 7F of my opposition, Lordship.
আমার রিপ্লাই পড়েছিস? রিপ্লাইটা পড়েছিস?
বলতে দাও না। Lordship, my 7F, Lordship, paragraph number 7F, and Lordship, his paragraph, the paragraph number 4 of his reply, where he has dealt with my paragraphs. May I only place, Lordship. কিরম করে টাকাও দেবে না, লোকও ঢুকিয়ে দেবে, দুটোই করবে নাকি?
আমি জানি না, তোর পজিশন তোর কাছে, তুই পারচেজ, তুই নিয়েছিস অকশন।
পাবলিক ব্যাংক, তোমার আমার টাকা রয়েছে।
জানি না, আমার কোনো লোকই নেই।
আচ্ছা,
আমি লোন পেমেন্ট করে দিচ্ছি, ছেড়ে দিচ্ছি, পজিশন তোর কাছে।
Where he denied page number 8 of the reply. I denied that the repetition creating any disturbance and peaceful enjoyment of auction purchase.
Lordship will kindly come to page 4 of the reply, Lordship. Page 4.
Yes.
Page 4, paragraph 4, Lordship.
Yes.
The bottommost paragraph, Lordship, it is however stated that the statements made in paragraph 7A to 7E are the admission of facts as narrated in the repetition and so forth. The statements made in paragraph number 7F, where I have stated that it is under his possession, Lordship, are out and out false and frivolous statements. The Lordship then will kindly come to the bottom post, the penalty made for the purpose of deceiving the petitioner from getting his legitimate claim against the fixed deposits, term deposits not being the subject matter of the loan amount, loan account. The said facts have been made with an obnoxious purpose and to harass the petitioner, who has been fortified by the no-due certificate by the bank concerned, and as such cannot be held liable for any sort of resistance.
Yes.
Any sort of resistance, obstructions offered to the auction purchaser of the property, namely Atul Anand. So Lordship, he is not denying that there was resistance in the property.
Resistance, but how?
He says that it is not through him. That everyone will say, Lordship. He says that no, it is not through me, but there is resistance, I know.
Okay, then let me decided who has purchased the property or not taken the possession. He will face the consequence. Why you are keeping the?
That suit is lordship pending. That's the reason that he has filed a suit. Lordship, I'm only praying for this much, lordship. The lordship will kindly direct them not to create any further obstruction, or if any created, they should stop from doing so, lordship. This is discontinue that. That would not, lordship, prejudice to anybody, lordship.
No,
There
but
is an innocuous prayer, lordship.
the court can go into that.
Lordship, if they are creating an obstruction either through him or through anybody, lordship, they should not do that. They don't.
He will not the party. He will be.
Even if,
order
lordship,
will be passed. It is only.
but that I have named
Where is the civil court order? You have a civil court order.
civil court. The English order was with. Lordship, I have probably annexed it with my opposition. Ashin?
Plaint and
Plain task.
written statement of it.
Who filed the suit? Purchaser.
Lordship, the auction purchaser.
Atul Anand. Against whom?
Against Lordship Anju Roy,
Who is Anji Roy?
his sister-in-law. Allegedly, Lordship, allegedly his sister-in-law. Alok Kumar Ghosh, that is his client, my Lord and friend's client. Ghosh Construction is his Lord and friend's client. And
As also against the bank.
bank kothay got it?
4.
Bank of
Yes. Do we now fourth bank? Performer defend. This defend number 1, Lordship, is related to him, the petitioner.
I don't know. Roy, Ghosh, কি করে related হয়? হয়নি গো।
এসে বলো কথা বলো না, আসবে না।
You are appearing in the suit.
It's not there.
So why you are not given the possession? It is
But
against.
I have not given.
What is your written statement?
My written statement is not
What is
here.
your written statement? 2019 suit.
But
What
my
is the
written
written
statement
statement?
is not here, my lord. My written statement, there is no written statement over here.
You
I
not
don't
for
have-
the written statement.
I don't have the copy of the written statement. And I have no way connected. They have taken possession. They have taken the possession on the basis of the possession in the 2019. Now they are all the joining the issue in. You will kindly see the suit number when they have filed the suit.
There's no injunction order. You are not having the injunction order.
Have been falsely been implicated as party respondent in the defendant in the suit. I am no way connected. I have paid the amount. After adjustment of the sale proceed, I have paid another 13 lakhs for one-time settlement of the loan account. And they have accepted the same. I have not filed any case.
This 8,18,470 and this is maturity amount.
It's maturity amount. And there is all other, you also kindly come to page 5 of my writ petition. This was filed on in regard to the subsequently there are other fixed which has already been all are matured, but they will not pay anything. Page 5. Details of my fixed deposits.
These are the total.
These are the totals.
Not single.
Initially was single when I filed the writ petition, but subsequently this has all are been matured. But they will again withhold the same.
So that is not the.
That is, I have not made any prayer to that effect.
You are only with regard to the 8 lakhs rupees.
Fine. It should not withhold.
The petitioner has filed the present writ application being aggrieved and dissatisfied with the action of the respondent number 4, the Chief Manager Bank of Baroda, Asansol branch, by not allowing the petitioner to withdraw the fixed deposit receipt, fixed deposit amount of rupees 8, 18, 479 being fixed deposit account number 004303001964 dated, which is matured on 30th December 2022.
May I only interrupt?
Counsel for the petition.
May I only interrupt? Then, due to non transferring the amount, I have issued a check in favor of one person. There is an initiation of 138 proceedings against for that.
Against you?
Against me for non-disbursing the amount by the bank. I have to face that, man.
Okay.
So kindly, I have annexed the same.
Or that you go to the civil court and put the damage.
That I will do.
Not the writ court.
That I will do. I am not saying
The-
what happened.
Police.
Effect of this.
The petitioner submit that. Petitioner submit that. Initially, the petitioner not release the bank. Accordingly, the petitioner has filed the present date application. Okay. Police. The learned counsel appearing for the respondent bank submits that. In the year 2012, the petitioner namely Ghosh in Construction has obtained cash credit facilities from the respondent number 3. Full stop. As the defendant, as the plaintiff, as the petitioner failed to pay the loan amount, accordingly, the loan account of the petitioner were declared as an NPA on 27th of July 2017. Full stop. Thereafter, the bank officials the bank has initiated proceeding against the petitioner for recovery of an amount of rupees 80,21,754.50 along with the interest. Full stop. Subsequently, the bank has initiated proceeding under the SARFAESI Act, and during the pendency of the proceeding,
The debts recovery act, Lordship.
under the death recovery,
I'm sorry.
before the death recovery tribunal, not SARFAESI, before the death recovery tribunal, and during the pendency of the proceeding before the death recovery tribunal, the matter was settled between the parties and the landed property. What is the where is the proper description of the property? Accordingly, the land of the petitioner was land along with the structure.
56 description of the property.
56.
56. That is sales agreement.
Land along with the structure standing on survey plot number 758 in survey / Khaitan number 119, JL number 22 in the district sub-district Asansol, district Paschimi Bardhaman, was sold by the bank on auction and realized the total due amount of risk. What is the total due amount was realized?
The total they have realized initially 12,40,000 from the sale proceed. Thereafter, it has been settled to 13 lakh.
I had realized the total due amount. Total due amount. Total due amount. Full stop. After the sale of the property of the petitioner, the bank has issued sale certificate in favor of the auction purchaser. But the auction purchaser has made a complaint to the bank that the petitioner is not is disturbing the possession of the auction purchaser, due to which the bank has not released the fixed deposit. Had the learned counsel for the respective parties peruse the materials on record. This could find that the bank has realized the total loan amount along with the interest after selling the property of the petitioner, and the property of the petitioner has been sold to the auction purchaser by issuing the sale certificate. The purchaser of the property in question has filed a civil suit before the London Court of Civil Judge Junior Division 3rd Court at Asansol, being titled suit number 49 of 2019. in which the allegation has been made by the purchaser against the petitioners that the petitioners are disturbing the possession of the purchaser. This court finds that the relation between the petitioner and the bank was this court finds that the petitioner has obtained loan from the bank and the petitioner failed to repay the loan, and accordingly the loan account of the petitioner was declared unpaid. After the proceeding initiated by the bank, the matter was settled and the bank has sold the property of the petitioner and realized the total amount. As regard the dispute of the purchaser and the petitioner is no way connected with regard to the fixed deposit of the petitioner which was lying in the bank. Bank has already realized the amount which is due against the petitioner by selling the property. Accordingly, this court did not find any justification by keeping the fixed deposit amount of rupees 8,18,479 by the bank without allowing the petitioner to withdraw the same. Accordingly, this court is of the view the bank has arbitrary and malified, it could find that the bank has illegally retained the fixed deposit amount of the petitioner in spite of the fact that the bank has already realized the total loan amount along with the interest after selling the property. In view of the above, the bank, who is the authority? Three. The respondent number 3 is directed to release the fixed deposit. What is the number?
The number is 00430.
That is account.
Page number bolo
Fixed deposit. This is account number. Where is the fixed deposit?
Fixed deposit account number.
Fixed deposit of rupees 8,18,479. Having fixed deposit account number 00430300019264, which has been matured on 30th December 2022 within a period of 2 weeks from the date of receipt. Date of list of, as the fixed deposit of the petitioner was matured on 30 December 2022, but the bank has kept the fixed deposit and the bank refused to release the said amount in favor of the petitioner in spite of having the knowledge that the bank petitioner has paid the total loan amount by selling his property. Accordingly, the bank is also liable to pay interest at the rate of 6% till the payment of the said amount from the 1st of January 2023. WPS disposed of.
Okay, Lordship, will kindly please to add only one line that Lordship, he will not create any disturbance in that property, Lordship. Only one line will suffice. Only one line, Lordship. It will not prejudice him, Lordship.
How this court can?
Lordship, I am only beseeching your Lordship.
Respondent petition order.
The however full stop. No, I am not. Yes. Next. Now, from the date of receipt, you comply with.
On the last occasion, my lord, Justice Amrita Sinha directed to file, my lord, supplementary evidence. May I file this?
My lord, I am for the state,
Yes.
led by Mr. Somnath Ganguly, my lord.
Ah.
My lord, I have come to receive information that Mr. Ganguly has been elevated. I was also led by his learned junior, Miss Pratiti Das. She is no more in the panel, my lord. I am the only one surviving member.
What
So-
problem, my lord? Learned said that.
Yes.
Now he is boss, my lord.
No, my lord. My lord is the boss. I am
lord,
your most
as the state-
obedient servant, my lord.
This is the matter, my lord, where, my lord,
But he is having some difficulty. Mr. Ganguly will not be there now.
No
However, my
problem,
lord, I have
because
received
state
the
is here,
exception.
my lord. Representative is
I have
here.
received the exception, my lord,
Ah.
from them. However, my lord, may I submit one point over there? My lord, pursuant to,
What is the difficulty?
my lord, the only difficulty is this is barred by limitation, my lord.
What?
My lord, the
What is
petitioner,
the claim?
My lord, about
Yes,
27 lakhs.
Security deposit, my lord.
About 27 lakhs, my lord.
27 lakhs of the security deposit.
Of the security deposit, alleged security deposit.
Ah.
My lord, they have come up after 14 long years, my lord.
Ah.
Limitation is only for 3 years,
That
my
is
lord.
not-
Now, my lord, on pursuant to Honorable Justice Amrita Sinha's order, on 1st of August 2025, my lord, her ladyship had directed the petitioner to file an exception to the report. The reports were taken in record, my lord. Now, what happened was 1st of August 2025, that order was passed. Now, my lord, the petitioner's, my learned colleague's client, the petitioner, just to show to the court that he still has, he is covered under the limitation, my lord. After the 1st August 2025's order, he went to the police station on 2nd of September 2025 and lodged a missing GD, my lord.
That is
Stating that
document,
the
my lord, but-
stating that the conversations, that the communication has happened with the state, and the state has allegedly replied that conversation is missing, so he has lodged a GD, and based on that he has filed the exception that here I have gone ahead to the police station and lodged a GD.
Yes.
Now, my lord, just by lodging a GD that it has been missing, that too after filing the writ application and after the passing of the order of the honorable court, is this sustainable? Just a mere allegation that it has been missing. Why he did not for
What
14
is
long?
missing?
The communication from the state, because they
That
have
is-
to show that there is some communication from the
No, my lord,
state's
that
end.
is not the-
Otherwise,
No, no,
they are
last question is,
sending.
my lord,
When the work was awarded, sir, to you, when the work was awarded,
Work order, you kindly come to my lord, page my lord, 18, my lord.
page 18.
18, my lord. That is a
Yes.
work order.
This is a work order of 17th January 2011.
Yes, my lord.
Correct.
And then subsequently, my lord, I made
Where is the security deposit?
some order, my lord. That is subsequent date, my lord. That is 30/12/10 and other things.
Correct, correct. Where is
But
the
other work order is not, that is missing, my lord. That I admit. And then, my lord, subsequently, you will kindly come to page 23. That is the sheet, my lord. Security deposit sheet, my lord. 23. I have all security deposit date-wise, geo member and also AC. All.
Page number, page number?
Is 23, my lord.
23.
Geo number, value, and sub value. Yes. And subsequently, all the total is, my lord, approximately 28,65,000. That is 80. That is page 25. Bottom portion. And then, my lord, I made several representation as far as this claim is concerned, my lord, security deposit. You should kindly come to my lord, page 32. That is the first representation, my lord. Before the
No, you were relying upon the work order appearing at page number 18.
Yes, my lord.
Kindly come to the date 17 January 2011.
Yes.
Correct.
Yes, my lord.
Then kindly come to the second page number 19.
Yes, my lord.
14 January 2011.
Yes, my lord.
Correct. Then page
That
number.
is some part of master document.
Come.
1/3/2011.
17 January 2011,
Yes.
1/3/2011,
Yes.
and 2010.
Yes.
Correct. These are all these things. Now kindly come to your completion certificate. Kindly come to the completion
Completion
certificate.
certificate, my lord, that is
Page 26.
26. Yes.
The agency has successfully completed the supply order 86 dated itna superintending engineer. Where is that?
16 lakh 9,200.
That is 2007 order.
Yes, my lord.
Now kindly come to the page 27, 2008 order.
Yes, my lord. That is the.
Then come to the next one, that is the 2010 order.
Yes, sir.
So this work order which completion order, completion certificate which you relied upon, that is prior to the work order issued to you.
No, that is what happened, my lord. I
don't know, but what?
Just
And 2011, where is the document to show that he has deposited the amount?
That is why I am mentioning in the supplementary evidence.
I am dismissing.
Illogically come to my lord.
The petitioner has filed the present writ application praying for the direction upon the respondent authorities for release of an amount of rupees 27,34,247.70, being the security deposit made by the petitioner before the Executive Engineer West Bengal Agro Industries Corporation Limited. The petitioner has relied upon the work orders dated 17 January 2011, 14 January 2011, 1st March 2011, 3rd December 2010, and the completion certificate
page 5
appearing at page number 26, 27, and 28. Perusing the completion certificate which the petitioner has relied upon, find that completion certificate is with respect of the work order issued by the authorities in the year 2007, 2008 and 2010, not 2011, which the petitioner has relied upon. Now the petitioner has filed the supplementary affidavit.
Page 5, madam. Page 5.
Supplementary affidavit.
Page 5, P5.
Supplementary affidavit with regard to the supplementary affidavit wherein the petitioner has disclosed one complaint made to the inspector in charge Behrampur police station dated 2nd September 2025, wherein the petitioner alleged that the communication made by the petitioner and the authorities have been misplaced, lost. Full stop. The counsel for the respondent has raised the point of mentality on the ground of limitation. He submits that the petitioner claimed that the work order has been issued in the 2011 and the petitioner has completed the work. But now, in the year 2025, the petitioner has filed the present application for claiming the security deposit, which is barred by limitation. Full stop. The counsel for the petitioner further submit that to buttress the case of the petitioner has made a false complaint to the police authority after filing of the present case, which is appearing in the supplementary affidavit at page 5.
This is not false complaint. This is missing all documents missing, madam.
2/9/2025. Full stop. Consider the submission made by the counsel for the respective parties. This court finds that the case of the petitioner that the petitioner is entitled to get an amount of rupees 27,34,247.70 with respect of the work orders issued by the petitioner, 70 being the security deposit submitted by the petitioner with respect of the several work orders issued to the petitioner, and the petitioner has completed the work, but the authorities have not released the security deposit. This court considered the work order and the completion certificate which the petitioner has relied upon. The completion certificate which the petitioner has relied upon is of 2007 and 2008, and the work order which the petitioner has relied upon the 2011 and 2010. Thus, this court failed to appreciate how the completion certificate has been issued by the authority prior to issuance of the work order. As per the case of the petitioner, the work has been completed in 2008 and 2007 and 2008. Now, after the period of 17 years, the petitioner has filed the present writ application praying for release of the security deposit. But the petitioner has not disclosed any document to show that the petitioner has any point of time has deposited said amount before the authority. Considering the above, this court finds that the petition filed by the petitioner is misconceived and barred by limitation. Accordingly, WPN number so and so dismissed.
I'm extremely grateful, my lord.
Kindly note it down. This last representation, my lord.
Yes, I recorded.
I
Yes.
made representation before the authority, my lord, 2nd of January 2014.
Yes,
Kindly note it down.
Yes. Next. Call.
This is my evidence of service, my lord. But this is for an application for extension of one of the lease agreement which expired. For the 2 years lease agreement with a renewal clause, an agreement was executed for the land, my lord.
But
after expired,
why the land has been given to you on lease?
For the purpose of use, for ingress and ingress, and for constructing temporary residential accommodation, whatever may be. And my lord, your lordship kindly, my lord, I made a representation before the authority.
Who is for the authority?
But the authority is the one of the.
You are appearing.
What happened? Let him finish.
My lord, this agreement, my lord, in Bengali, I have annexed it. My lord, page 18 is the, my lord, I'm sorry, my lord, page 18, clause 1 is the main clause. My lord, I have made one translation through Google, my lord. If your lordship kindly pardon me. But this particular clause is the relevant. The first clause, your lordship kindly see. Second paragraph of the first clause started.
Permission from the first party to construct the use. Yes, from first day of Baishakh, Bengal, so and so, first day of Chitra, so and so, second party have obtained permission.
And the last two lines, man.
If the second Second party will submit the design to the so. Where is the extension clause?
Malad, last line, Malad. After the expiry of the period, the first party, if comply all the conditions, next 2 years agreement will be renewed. But you got it, Malad. Last two lines, Malad. Last. At the end of the period, if the first party,
Which paragraph?
The first paragraph, Malad. But the page I have given to you.
Which portion?
But the first paragraph, last two lines, Malad. But at second page, the second paragraph, last two lines. At the end of the period, you have got it, Malad.
Show me where from your.
I have marked, Malad. At the end of the period, if the first party complies with all the conditions, the agreement shall be renewed every 2 years. Therefore, Malad, the first term of the agreement, I have complied. There is no allegation whatsoever.
Which period to which period? First agreement?
First agreement was 1st Boishakh, Bengali calendar, 31st Chaitra of Bengali calendar. But it expired according to
Chaitra of Bengali calendar. So what is the date in the English calendar? 14th April
2025.
14th April 2025, your lease is over. You are still in occupation of the premise. Okay. Then what do you want? Accept.
Presentation before authority for renewal. Because I have.
So when the agreement was entered?
When agreement was entered, Malad. April 2023.
For 1 year?
For 2 years.
2 years. Where is the date? Agreement date?
Your Lordship, on page 21. It is 12 September 2024.
12 September?
2020.
12 September 2024. Now, what is the date of the agreement?
Your Lordship, and the first paragraph, and I have just placed, it has been categorically stated. First paragraph. নিম্ন সবসময় বর্ধিত জমি বাংলা 1330 সালের 1 বৈশাখ তারিখ হইতে বাংলা 1431 সালের 30 চৈত্র অবধি.
What is the
period? And so far as the amount that has been paid, that I have. And this agreement was accordingly entered into 12 September 2024.
12 September 2024 agreement over. Time period is over.
No. This agreement was executed on that day. But
so that's why I am, sir, specific. I am asking from which date to which date your agreement is valid.
From my lord, April 23 to April 25.
Date.
The 15th April 2023 to 14th April 2025.
Yes. When you made the representation?
I made the representation in the month of June 2025.
After this.
Then, because they never stated that it should be made prior to that. They only say if there is no objection from their end, from any corner.
That's why the agreement at the end of the period, if the first party complies with all the conditions, then you have to apply for.
But I have applied, mother.
When? After the June, after 2 months.
After 2 months. But
then
I waited. Your Lordship can see.
Yes, what is the contention?
Lord, some objection has been raised. Lord, some objection has been raised by the nearest inhabitants. After taking the lease, the said lease land is for the interest of so many persons. After taking that lease, he has restrained all others not to use the same. Other previously when he has not given the lease, other persons are there. he was allowing them to use the same. So some objection has been raised. Lord, Jilla Parishad Lord taken decision to take a hearing. That is, tomorrow is the date of hearing. It has been fixed, Lord. Let me take instruction on Lord. Lord.
You have issued the notice to him.
I don't know. I have got
What hearing?
For hearing of the objections. In the of
Objections, so he has to give the notice.
Perhaps he has been given notice. Perhaps we have.
Have you received the notice?
Lord, let him contact me. I will inform him today. What is the date of whether he has given the notice or not. Lord, I have got instruction.
Give me the exact date. I will tell that the opportunity be given and you place the report here. When?
Let him dispose of Lord by directing Lord.
The petitioner.
Objections.
Okay, the petitioner claims that.
No.
Piece of property.
Who is that part? He has left that place. Other person who are living there.
2 years with effect from 15th April 2020 to 14th April 2025. With the condition that at the end of the period, if the first party complies with all the conditions, the agreement shall be renewed every 2 years. Petition submitted. The agreement period was over on 14th of April 2025, but the authorities have not renewed the lease agreement of the petitioner for a further period of 2 years, and accordingly, the petitioner has made representation to the authority on 5th of June 2025 for consideration of the case of the petitioner for extension of the lease period. Police subpara. Then at counsel appearing for the respondent submit that submits on instruction that the authorities have received objections from the villagers and the authorities have fixed the case for hearing and the authorities will decide it accordingly. In view of the submission made by the counsel for the respondents, this court did not find to keep the this court find that no purpose should be served if the writ petition is kept pending. According, the writ petition is disposed of by directing who will decide.
Lord, respondent, Lord.
Respondent number 4.
Lord.
Let the respondent 4. Directing the respondent number 4, that is the block land and land reform officer.
No.
Respondent number 4.
Respondent number 4 is the Purva Medinipur Jilla Parishad.
The land manager having office.
Who is the authority?
The authority, Sabhadipati is the authority. He has not made party Sabhadipati.
Who will decide this?
Sabhadipati will decide this.
Sabhadipati cannot.
Lord, then Lord, that is the secretary.
You are having the executive officer in the Jilla Parishad?
Yes, secretary is there. Secretary.
But he is not a party here. Land manager, he has given.
Land manager is the authority. He is not the authority.
So you have given the representation to
land manager is the authority.
He is taking look
to consider.
He is the dealing assistant.
Number 4.
The dealing assistant.
The Purva Medinipur Jilla Parishad. Jilla Parishad is directed to consider the representation filed by the petitioner after giving an opportunity of hearing and to pass a reason and speaking order within a period of 4 weeks. 4 weeks. 4 weeks from the date of receipt of the writ application. This order. Police WPA number 76 disposal. After hearing the parties, giving an opportunity of hearing, affidavit be kept. Next.
If the date is fixed, Lord, that is fixed, Lord, for your Lord, Lord has also Lord mentioned.
I recorded your submission, that's why you referred the matter. Inform your authority, give the opportunity and pass an order. Yes, next.
Item number 8.
My lord, I appear for the petitioner in this matter, my lord. My lord, very peculiar set of facts, my lord. Not the usual run of mind. My lord, that marriage registry
under the Marriage Act.
Now, my lord, the issue over here is, my lord, the marriage had been solemnized on 11th of May 2023. Now, my lord, for this particular area, my lord, which is Chetla Police Station, there are 2 kinds of marriage registrars which can be appointed in terms of the West Bengal Hindu marriage rules, my lord. One is, my lord, an ex officio Hindu marriage registrar, and the second, my lord, is a non-official Hindu marriage registrar. Now, my lord, the ex officio marriage registrar, my lord, is usually the additional district sub-registrar who registers, my lord, all the. And, my lord, insofar as the non-official marriage registrars are concerned, my lord, it needs to be notified by the government. And, my lord, that has not been done in respect of this present particular area, my lord.
Marriage officer is there, why you're not going to the marriage office?
My lord, the marriage officer has indicated that he's not equipped. That is the difficulty. Now, my lord, in any event, the district sub-registrar, and that is, my lord, also the spirit of the statute, my lord, the ex officio marriage registrars, my lord, they're burdened with n number of things, my lord, which is like registration of various other documents. And that is exactly the reason why, my lord, the non-official marriage registrars are appointed in terms of the rules. Now, there is not a single non-official marriage registrar deputed for that particular area. Now, my lord, the difficulty is we have approached the ex officio marriage registrar, my lord, who's also the additional district sub-registrar Alipur, but he's not in a position, my lord. We have also applied. I've prayed for, my lord, for appointment of non-official Hindu marriage registrar, my lord.
Yes, what is that?
May I submit? My lord, admittedly, this is a burning issue by which the entire state is being affected. But, my lord, the fact is that, my lord, your lordship kindly takes up page 3 of my report, my lord.
Report.
The judgment there.
My lord, if I may be favored with a copy, my lord.
A specific notification was issued by the government of West Bengal in connection with the distribution of the jurisdiction annual fixation of the marriage register officers. Several marriage register officers, my lord, have approached this honorable court and against the notification, my lord, and the same has been stated since 2024. Your lordship kindly comes to page 3 for once. Page 3.
Yes.
The 248 petitioners before the courts are non-official marriage officers who are aggrieved by a notification dated so and so issued by the Law Department, Government of West Bengal, in excess of the power, confidence section 3 by 1 of the Special Marriage Act. Now, my lord, your lordship kindly comes to page 2, the internal page 2, page 4. The grievance of the petitioners may be categorized in the following manner. First, the petitioner in some of the petitions are aggrieved by the restriction of the area of operation, and the petitioner in the remaining writ petition are unhappy with the restriction of operation only to a particular police station. The common canvas of grievance is that the petitioner were appointed in 2001 for multiple districts overlapping each other and continued to function within the area from 2001 onwards. A few of the petitioner were appointed in 2015. Now, your lordship, be kind enough to come to page 6, internal page 4, paragraph 8, 9, and 10. My lord, the relevant part is paragraph 10, my lord. The argument of the notification being issued for addressing the alleged unequal distribution of non-official marriage officers and to bring about greater parity in terms of their functions must be sustained on further documents disclosed by the state respondents. Till affidavits are filed, the state respondents are restrained from giving effect to notification or any circulars issued pursuant to thereto, including 4422 in any matter. So, my lord, as on date, our hands are tied by this order, my lord.
No,
But
the argument of notification to bring about the greater parity in terms of so-and-so, substantial and further document disclosed by the state till affidavits are filed by the state respondents. So, what has happened to this?
It is still, the matter is still being stayed. And my lord,
so where is the matter now?
No, the matter is
Which
pending
court?
before this court.
Which court?
No, this matter is pending.
Which court?
It is supposed to be appearing in this court only.
Correct. So if it is pending, then I will list
My
this
lord,
matter along with-
kindly direct all these matters,
Correct.
checked in and get.
All the matter can be taken
My lord,
if
my lord,
affidavits are completed.
Absolutely, absolutely.
Then the matter
Because
can
not our hands are tied, but we are going.
See, even the officers who have been appointed as a marriage officer, marriage officer is appointed according to the district. Marriage officer cannot act as marriage officer from the other district unless and until a specific notification is clear. Here, you have given, because there are so many candidates, the police station wise you have given the permission to the person to conduct the marriage as a non-official marriage officer.
Officers, I think, under 2 or 3 police stations.
No, that's why, whatever. Let the conscious,
let this
the conscious decision be taken by the authority.
Milord, admittedly in Chetla area, there is no marriage register as on date.
Correct, that's why you
Milord,
can.
one Mr. Paromita Pal has applied. But in view of this stay order, Milord, our hands are tied, we are not being able to proceed. Milord,
Whether this case is pending before this court.
Now, Malad, the difficulty with the writ petitioners, and I believe, Malad, this would be the case with n number of individuals.
Absolutely.
Because, Malad, until and unless in the situation, Malad, where one of the couple decides to have their marriage registered in terms of the Hindu Marriage Act,
In
Malad,
case, Milord, kindly
the difficulty would be
the ex officio, Milord, to take some steps.
the
So,
difficulty.
Milord, we have requested the petition.
Where is the denial of the marriage officer?
I beg your pardon, Your Lordship.
Where you applied for the marriage officer? Have you applied for?
My lord, I could not because the online application form provides for the police station. I have applied and it says that there's no marriage officer designated for this.
Kindly comes to
And it is an admitted position.
Page 2, paragraph 5 of my report, Milord. It speaks otherwise. Milord, it indicates, Milord, the petitioners was requested to apply online to ex officio in the marriage register, so and so. With this office communication made through email as attached in page number 13 of the writ application, but he neither appeared nor filed any application through online portal before the ex officio.
My lord, I have applied. I have annexed those documents to my application, my lord.
32 to 39.
My lord.
32 to 39.
Yes. And my lord, thereafter, if your lordship kindly takes up page 47. This perhaps, my lord, is the most important document. Page 47.
Non-official marriage officer, Hindu, Kolkata, Chetla, no marriage officer found.
Now search by, my lord, your old police station, Thana. Now, my lord, that's
Official, no. You go
Ex
to
officio.
ex officio.
ex officio, my lord, the difficulty.
Where is the application for the ex officio?
That is not
My lord, there's my instructions are, my lord, there's no online application portal, my lord, for applying before the ex officio marriage registrar.
Let the petitioner or the applicant approach personally, Milord.
My lord, we have approached personally. We have been
Approach
declined
personally
the.
with a hard copy of the application, Milord, and let that
We have been
dealt with.
declined, my lord, on 3 occasions. The petitioners have been running from pillar to post, my lord, over the past 2.5 years, my lord.
You take instruction from the ex officio who is at present, who is the ADM. You take instruction. I am keeping next week. I will pass an order. Tell him I will pass an order. He will approach the ex officio officer with the physical application and take appropriate step for
Milord,
registration as a special case.
Milord, kindly direct the petitioner, Milord, to approach the ex officio. And Milord,
First you take instruction whether what is the difficulty of the ex officer. That's why if today we will pass an order, if he is having some administrative difficulty, then it will be difficult.
And Milord, the other writ petitions, Milord, may also be heard.
I will take that, but you take.
Initially, Milord, these steps are to be taken.
You take instruction.
Absolutely.
So as a special case, the court will pass an order. You do that.
Very
My
well.
Take instruction. Because I am not passing any order. If any other executive exigencies or what, we don't know.
Absolutely.
You take instruction and come on that. The petitioner has filed the present application with the grievance that the petitioner has applied for registration of the marriage, but it was found that no non-official marriage officers and Hindu under the Hindu Marriage Act is available at Chetla police station.
Milord, kindly make it, Milord, 2 weeks, Milord, kindly.
Chetla police station. Full stop. Learned Counsel appearing for the state has submitted the report and draw the attention of the order passed by the coordinate bench of this court in WPA number 9265 of 2023, dated 25th of April 2025, wherein this court passed the following order. Inverted comma. The argument of the notification being issued for addressing the alleged unequal distribution of NOMOs and to bring about greater parity in terms of their function must be substantiated on further documents disclosed by the state responsible. Till the affidavits are filled, the state respondents are restrained from giving effect to the notification dated 8 February 2023 or any circular issued pursuant thereto, including 4/4/2023 in any manner. Inverted comma close. The counsel for the state submit that due to this order, the state respondents are not in a position to to give any effect or further effect for allowing the NOMOs to act as a marriage, non-official marriage of. Full stop. Considering the submission made by the counsel for the parties, the petition, the state respondent, the learned advocate appearing for the state is directed to considering the submission made by the counsel for the parties, the state respondent and the advocate appearing for the state respondent is directed to take appropriate steps from the ex-marriage officer of Chetla.
My lord, not Chetla, my lord.
Of which district?
24 of the concerned district, my lord.
Of the concerned district to take instruction in the matter within a period of 10 days.
My lord, kindly makes it 2 weeks, my lord.
Period of 2 weeks. Within a period of 2 weeks. Full stop. In the meantime, the department is directed to see whether WPA number 2015 of 2025 within bracket Somnath Banerjee 2025 no WP number 9265 2023 is pending before this court within bracket Anshuman Padikar and others, another versus the state of West Bengal and others, and connected writ petitions are pending before this court or not. If these writ petitions are pending before this court, be placed before this court along with WPA number 20915/2025 on 16th of December 2025 under the heading adjourn.
I think there are 4 writ petitions.
Yes, along with connected.
My lord, 4 writ.
Okay.
Grateful, my lord.
Next. Yes.
My lord, the sawmill in front of my house. On 6/11/2025, Lordship was kind enough to hear this matter first time and directed them to file their affidavit within 2 weeks. Within 2 weeks. My lord, 4 weeks have been elapsed, no affidavit, and they are running this mill, my lord, merrily. And my lord, the pollution, my lord, which is called sound pollution and dust pollution, my lord, make my life miserable. And my mother not in a position to live in her own house. She has to, my mother, my lord, my wife, sorry. But that being the situation, she has been suffering from different ailment at the same time, this sound pollution.
Okay.
And
Yes, where is the affidavit?
The client could not contact me, but he was
You are appearing
no,
for?
respondent number 9. Let there be no operation of, my lord. Let there be no operation of this sawmill, my lord.
Yes,
My lord,
let
kindly
me
comes.
understand. Yes, you are for the private respondent.
Private respondent.
Who is for the authority?
I'm for the state.
Yes, where is your affidavit?
I will extension of time, my lord.
I will impose cost.
Deeply obliged, my lord. Kindly, my lord.
I will impose cost.
Kindly, my lord.
My lord, pay 24, my lord.
If you want to argue the matter without the affidavit, I'll see the 24. If you want to extension of time, I'll impose cost. Choice is yours. Which you prefer? You want to prefer without the affidavit, I will hear the matter without the affidavit. If you want to file an extension of time, I will allow the extension of time for payment of cost. Huh?
Let this be heard of.
Heard it? Yes. Yes,
But I am yet to receive any copy also.
My lord, here is this copy.
I am yet to receive any copy from their end.
Not given the copy.
No, that being the situation. So, my lord, my humble prayer, my lord, 2 weeks time granted by the high prerogative writ jurisdiction. This is a question of my life. And my lord, they had handed over a copy now, my lord, in court.
How soon you will file it?
My lord, within a week, my lord.
Within a week.
Within a week, my lord. This since we are suffering a lot.
I am imposing cost. That's why if you I am putting to you. I am giving time to reply. If you want to file the affidavit, I put the cost. That is clear. Before this court, no hanky-panky. Once the order is passed, it has to be complied with. Otherwise, you have to face the music. The private respondent number 9 has filed affidavit in opposition after serving the copy to the London Counsel for the petitioner. Let the same be kept with the record. Counsel for the petitioner pressed for time to file affidavit in reply. Full stop. Counsel for the state respondents have not filed the affidavit in opposition and submit that he will argue the matter on merit. Accordingly, Chance to file affidavit in opposition by the state respondent is closed. Full stop. The petition director filed affidavit in reply on or before 9th of December 2025. List the matter on 11th of December 2025 under the same heading.
Deeply obligement.
But I have served in the copy of the affidavit.
Yes, next.
May I please, your lordship. My lord, I am the purchaser of a vehicle
Yes.
financed by Tata Capital. Tata Capital. Now, what happened? I was paying the, my lord, installments. My lord, kindly look at page 19. The installment started from September 11, 2024. Admittedly, yes.
You obtained loan in September 24.
Yes. And my lord, it would end in 11th February 2029.
Correct.
Now, I was paying. Admittedly, my lord, there are defaults in payment of 2 installments. On August, my lord, they took up the vehicle. They have taken possession.
August of 2020?
25.
25?
Yes, yes. On 18th August, one kindly see the seizure list. And I have repeatedly said that I am ready and willing. There was some difficulty. Still, I am ready and willing to pay the installment.
What is the amount total pending?
Now,
against you?
Against my lord, it will be now till date 6,70,000.
What is the total amount you have obtained the loan?
Loan, my lord, I have not obtained. This is the, my lord, they have financed. It would
Correct.
be 60 lakhs. 60 lakhs.
60.
60.
60.
Yes.
Correct.
And I am to pay, my lord, till, my lord, kindly see the agreement, February 11, 2029.
Correct.
I am paying. Now, presently, my lord, dispute is, my lord, when it filed, my lord, 2 installment, now it has become 6,70,000. Now, it is my instruction, we are ready to clear the dues. Vehicle should be returned to us.
And for the Tata bill, I have been asked to attend the morning. Kindly see page number 10. The petition is not maintainable because they are seeking a mandamus in respect of the private parties. Tata Capital is a private entity. Para 10, page 10, mandamus commanding respondents 1 and 2 to return the vehicle. And Tata Capital, they can file a section 9 application and arbitration.
And what happened?
Clause is there.
No, I can see a later
No, in the
where there is, they have indicated that arbitration proceedings is pending.
You show me the arbitration is pending or arbitration clause is available in the agreement entered between you and the party.
That petition I don't have. Kindly see the letter. Arbitration is pending. Page number 30.
Page 30?
Yes, I mentioned it. I have mentioned the petition also. Yes. They filed, my lord, an arbitration in Delhi.
Who filed?
The Tata Capital.
Against you?
Against me.
For recovery of this?
Not for recovery of this. They have asked, my lord, 56 lakhs with 36% interest. My lord, we have appeared there.
No. This arbitration is connected with the same loan.
Yes, same loan.
Same loan.
Yes.
So how is the writ petition?
No, my lord, I am telling you, to your lordships. Then, my lord, we approached there that we are ready to pay. Then the arbitration court said that when you approach the Calcutta High Court, if you are ready to pay there, that will be dropped. But I asked for an order. This verbally the court said. So, my lord,
dismissing.
No, my lord, kindly, I am ready and willing to clear the dues.
Go before the arbitrator, pay the amount, settle the dispute.
No,
get an award.
The arbitration is saying that when you are in Calcutta, you approach the. We said that we have filed a writ petition. Then the arbitration said.
Maybe, but how the once the arbitration is pending, how the court the writ petition can be maintained?
But the arbitration observed that you when you approach the Calcutta court.
Maybe they observed the court has to go by the law.
My lord, I am ready. But
you go before the arbitrator. Pay the
I have not gone. They have gone.
Yes, you go. You are the party.
I was made party.
You are the
I was made party.
It's their claim.
No.
You go and pay the amount.
So my lord, I am ready and willing to pay the dues, admitted dues, installments. Vehicle is under their custody. I am suffering loss. So your lordship, my lord, for this sake of my lord equity, we are not asking.
Equity cannot change the law, sir.
So I am asking that, my lord, they should return the vehicle. I am ready and willing to pay.
That's why you go before the arbitrator and
arbitrator said, my lawyer from the Delhi said that the arbitration verbally observed that when you are in the Calcutta, you approach the court. If you pay the dues, we shall drop the arbitration. My lord, kindly.
He will drop. He will pay the amount.
Well, subject only, I have to seek instruction on that, but when the read preparation is not maintained.
Correct, that's I'm telling, but once you're,
That means he can apprise before the arbitrator, Milord, there.
correct.
to apprise.
If you take instruction, whether this instruction has been given to your advocate, better you will pay the amount, then they will withdraw the amount, then I'll pass the order herein now and both can be disposed of.
I'll seek
Or
instruction.
I am dismissing his and you go to that.
Yes,
No, no, my lord, kindly, because that court,
If you withdraw that, then we'll see to that,
no,
otherwise.
my lord, they are one in daily observed that my lawyer said that he apprised. He said that when you are ready to.
So you pay the amount in the arbitration, I am dismissing it. You pay the
No, no, my lord, kindly.
The petitioner has filed the present date.
Then my lord, kindly, I am withdrawing this.
Praying for allowing the petitioner to, yes,
Then my lord, without dismissing, we are withdrawing it.
the counsel for the petitioner prays for withdrawal of the writ application. Accordingly, WPA 25095/2025 is dismissed as withdrawn. Interim order is pending, stand vacated. Affidavit.
Because my lord, they have prayed that
Okay, go.
with 36% interest.
Yes. Next.
Malad, in this matter, Malad,
I appear for the petitioner.
Malad, before my senior moves the matter, Malad, in this matter, Malad, Mr. S.C. Prasad is appearing for the registrar of companies, Malad.
Who?
Mr. S.C. Prasad, Malad, is appearing for the registrar of companies, Malad, and he's the answering respondent, Malad. So, Lordship, I am only praying, Malad, he's not well, Malad. He has not come to court today, Malad. But upon instruction, I am submitting.
Okay, I will hear Mr. Ghosh and the other party for your. I am fixing on Saturday at 10:30.
Malad, kindly, Malad, he will come to court tomorrow.
That's why you were advocate. I am accommodating you. You take note. You are the chamber junior. What Mr. Ghosh will argue, then you take note of it, and I will fix a specific matter on Saturday at 11 a.m. Come. By that, I think 4 days you will be recovered from the illness.
Malad, kindly, Malad, only.
It's a very short matter. My learned friend will be able to assist your lordship anyway, my lord. My lord, I am the petitioner number 1 and 2.
Only one thing, Mr. Ghosh, I am being led by Mr. Ratnavendra Banerjee in this matter. Your lordship, he will and we has requested me that we start, but I will come and argue. That is the only.
Well, it's very short matter. I think both my learned friends won't be very troubled, my lord. My lord, I am the petitioner. I am the petitioner 1 and 2 are the directors of the petitioner number 3. And the respondents 3 and 4 are the private, are the other directors. Now, suddenly one day I find that I have ceased becoming a director. There's no removal, there's no resignation. So I get a notice from the ROC saying that the form DIR 12 has been loaded and you are no longer a director. Ceased. I had appointed new directors. All of us have been direct. That's at page 274. 274, my lord will see. Second volume. So I get this email. I am Vimal and Pratik Godha, 274, my lord. So they say as of 10th of October, I have ceased becoming a director.
You are?
Vimal and Pratik, they are petitioners 1 and 2.
Yes.
So this notice we got, and at page 275, we made our representation that this is not, because there's no resignation by us, there's no removal by us. This has been done, and then we are told at the behest of respondents 2 and 3,
yes.
3 and 4.
Yes.
Now, this particular DIR, I have asked for copies in my letter at page 275. Your lordship will see the last paragraph. I request a copy of the filed form DIR 12 to be furnished to me at the earliest. Till date, I have not got the DIR. So even if my learned friends comes back, I would want one prayer that let them produce this DIR. Secondly, my lord, now the day we filed the writ petition, we got another notice from the ROC issuing a show cause. My lord, that, my lord, is in us. I put after we filed. My lord, so I have made a supplementary affidavit. We will serve them if your lordship grants me leave. In that supplementary, if my lord comes straight away to page 5, is a show cause by a ROC. And if my lord comes to page 6, just one line, let them reply to this. Paragraph 9, page 6. It is noticed from NCA portal that DIR 12 has been filed
for resignation of directors and so I have allegedly resigned under 168, whereas the form has been filed for resignation of directors. No resignation of a letter from any director has been attached, and the said e-form has been digitally signed by the directors. This is 2 and 3, respondent 3 has signed, and the PCS Pallavi Bhagat. Hence, from the above, it is seen the directors have been removed, mentioning incorrect sections without attaching correct documents. So even the registrar doesn't have the documents, and they have on the portal suddenly, I am a 52%, we are the 52% shareholder, we run the company, they are more or less sleeping partners. And thereafter, explanation has been asked from Abhishek Jain, that's the respondent 4, my lord. So let them reply to the supplementary, leave be given to file this. And in the meantime, they should not give an effect, or unless it's kept for tomorrow, then I won't say anything. If it's
tomorrow, my lord, tomorrow.
Huh? Till then, some protection. I am still a director.
I don't think, my lord.
There's a maintenance issue regarding communication, which is I like to argue. It's a case of mismanagement and operation. That is evident. One second. That is evident from para 3 regarding approval of director, efficacious and effective.
But
this is on the ROC.
I don't know, but you have to place the record what on whether.
I don't have to write.
That's why they has to place the record whether they have all the procedure.
Without the resignation letter, they shouldn't have.
Procedure has
Without
been
giving an
followed or not?
opportunity.
Where they are seeking for in a writ petition, the disputes squarely is covered under 241, 242. Because why I say so? There's an interstate disputes between the board of directors. They have also removed 5 directors from mine. We have also made a complaint. Interstate disputes are lying. Our ROC is inquiring into the issue. It is not about the inaction of the ROC. So there are interstate disputes between the directors. Boardroom disputes are to be brought within the purview.
I am only concerned with the ROC's
Has
actions.
filed supplementary affidavits disclosing certain documents. Let the same be kept with the record. The petition director to serve the copy, the supplementary affidavit along with the document.
We have served, my learned friends.
The respondents press for time. According case adjourned, let the matter appear on 8th. 8th December.
But 8th is the Monday. Well, tomorrow, if it can be.
Tomorrow, I don't think.
Then, when Monday, it's Monday, they want to hold it. But some protection should be given to us.
The issue of maintainability.
It is.
We are appearing for.
Respond number 3 and 4.
Counsel for the respondent 3 and 4 raise the point of unitary. The same is kept open.
But prima facie, they should not take, the ROC should not take any further steps.
Till this time, we have not taken any step.
Because I won't be able to write a letter also that I am the director.
Only 1 day is there, my lord. Yes.
This is the affidavit of service.
First, you have to satisfy them.
Affidavit be kept with the record.
Clearly maintainable, my lord. Because it's against the ROC. My fight with the directors will be separate. And they have been asked to, your lordship gives that direction, they should produce the DIR 12 form. ROC should. The ROC should produce them because they have not given us the form.
Register of Company is directed to bring all the connected documents on the
impugned DIR 12 form. The numbers given in the petition.
Disputed question of fact. They are saying that they have resigned. I am saying that they have resigned.
That's why let him produce. That's why whether he have followed the procedure, nothing remains. If it not follow the procedure.
Disputed question whether it has been done or not.
What has been done?
Yes, next.
Deeply obliged, my lord. Deeply.
It will be the same position.
Well, lordship, I am for the petition.
Same position. It will be in the same position.
Yes.
Lordship,
That's the same urgent motion.
Lordship, this is a new application for domestic connection. Lordship, CSC authority went for inspection. Private respondents objected, and therefore they could not give the connection.
Where is the notice to the private?
Lordship, I have served.
You made a party?
Yes, yes. Both of them are parties.
Who? Amita. Amita and Namita.
This is my affidavit of service.
Third.
Third, Lordship, but
address is correct or not?
Yes, yes. In the same premises, they are objecting.
It's not served.
Lordship, it is.
Amita served. Booked on, delivered on. Where is the Namita? Delivered on. Yes.
Lordship, they are objecting, and that is why CSC authority could not make the inspection. Lordship, on similar circumstances, Lordship was pleased to pass an order. Lordship, I am with the order. Lordship, that was 10 and I am the co-sharer in this case.
Kindly come to page 3, paragraph 5. Peter himself stated that what is our position, my lord. We went for inspection after he has made the application.
Correct, there is an objection.
The objection from the private.
Lordship, we will be praying for police help and
So who is Amita and Namita?
Lordship, they are also the other co-sharers.
Sharer. So you want the new electric connection?
Yes, new.
No connection is there.
Lordship, I have stated that there was only one connection in my name, in my mother's name, in Lordship Kullani Mundol. After her death,
Actually, there was a electric connection in the name of the mother.
Yes, Kullani Mundol. But after her death, the said meter has been changed in the name of the private respondent, Lordship. Respondent number 4. And I am not getting the connection, Lordship. And now they are objecting, I am without the
Where is
electricity.
that application?
Lordship.
When you filed? Page 11.
Lordship. That is the page 13. Their inspection letter of the CSC.
Page 13. Now your application?
Page 13.
Page 13 is the inspection report.
Yes, after the application, they have issued the letter.
So can dispose of? Can I dispose of?
But first, my lord, first inspection, first
Correct.
thereafter, if feasible for the supply.
So submit report.
Yes,
submit report I am fixing on next week.
Lordship, what I am praying, Lordship, kindly sees the last order passed by Lordship. Not in this matter, Lordship, the order I have handed over. Same order I am praying. First, they will make inspection with the help of the police. Thereafter, if it is feasible, they will give the connection with the help of the Lordship local police station.
The petitioner has filed the present application for grant of electric connection. It is the contention of the petitioner that there was an electric connection which was in the name of the mother, Kalyani Mandal. After the death of the mother, the said meter has been changed in the name of the respondent number 4. And now the petitioner is without any electricity. The petitioner has filed an application for grant of electric connection, the CSC authorities have visited the premises of the petitioner, but there was an objection from the private respondents, due to which the authority could not inspect the premises to ascertain whether there is a feasible for the CSC authority for grant of new electric connection in the premises as prayed for by the petitioner. In view of the above, the CSC authorities are directed to inspect the premises of the petitioner on Friday you can go.
Friday at 2 p.m. This Friday
On 5th of December 2025 at 2 p.m. in presence of the petitioner. The petitioner is also directed to remain present at the time of inspection to identify the place where the petitioner intends to have an electric connection. And it is made clear that at the time of inspection by the CSC officials, if any obstruction is made by the private respondent or any other persons, the concerned police.
Respondent number 3, Lordship.
The
Haridevpur police station.
The officer in charge, Haridevpur police station, shall provide appropriate police protection to the CSC officers for inspection of the premises of the petitioner
at the cost of the petitioner
for grant of electric connection. And if any cost is to be paid, the same shall be borne by the petitioner. Police staff. After the inspection, the CSC authority shall come with their report before this court on 9th of December 10th of December 2025. Release the matter on 10th of December under the same heading.
No notice is.
No, I had got it.
If the meter box is padlocked,
that on that you give the inspection. What is required then?
Report. Give the okay,
Great. If the lock is there or not, give the.
I file my report.
That's 10th of December.
No, in this matter, your lordship is to direct me.
Before my senior starts, my lord, I want to indicate that we are the flat owners in respect of the same building, which is.
I have not brought.
Yes, lordship, we have filed an application for addition of parking. My lord, it is can 1. My lord, it is not appearing today. Lordship, kindly pass a direction so far that application is concerned on the next day. It will come.
What is the can number?
Can number 1 of 2025. That is one.
I'm appearing on behalf of the East Kolkata Wet.
Your Lordship, in this matter, Your Lordship needs to direct me to submit a list of the cases pending writ petitions where I have challenged the various of State Act on wetlands or seeking a declaration that State Act became redundant in view of the proclamation of that new central rules 2007. These are the list of cases. That my Lord, Deputy Solicitor General said this one bench has been constituted by this our division bench, Chief Justice. I just clarify this. Why, my Lord, this is, it will not come under the purview of this. I just pressed it. But you also can see first.
Okay, in that case, now they filed an application for addition of party.
So they are my all flat owners.
What is the number? Let the matter.
Can one.
Huh?
Can one
Can
of
one.
2020.
Only one application filed.
One.
Let it become on the next week.
But there's interim order on their behalf.
May I most humbly beseech your lordship that kindly let there be a direction on my learned friend to serve a copy on all the respondents.
I have not been served, but they will serve.
Can one.
Yes, can one.
I will serve mine.
Yes.
I have served, but I have never.
Yes, this is.
Yes, that I will that I clarify, my Lord.
All this matter has been relegated to the High Court. Now, Honorable High Court,
No, that's right.
Tandon was looking after these matters. Subsequently, it went before the Honorable Chief Justice. All these matters are pending. But your lordship knows better than us in terms of Ramasar Convention. Not the property, this property, the East Calcutta wetland is also come under the
Yes, wetland.
Now, pursuant to that direction, I think all of their.
That's why. Let the can come. Yes. On that day, I will hear all of you. I find that not the.
Yes, allow me to clarify. Yes.
The division, but then it will let the can come first. The. It is submitted from the bar. Some of the applicants have filed an application being can 1 of 2025 brings for addition of parties. But the said application is not on record. Accordingly, the department is directed to place the can number 1 of 2025 in connection with WP
11.
A 25827 of 2025 before this court on 11th of December 2025. The applicants, in the meantime, the applicants who filed an applicants of can number 1 of 2020 were directed to serve the copy to all the to the petition as well as all the respondents.
But interim order be extended. Interim order is there for
this condition. Extended till 11th of December 2025.
Make it urgent.
December?
Under the same heading.
Yes.
11th under the same heading. Next.
Grateful, your lordship.
14, my lord, I am for the petition.
I am for the respondent union of India.
My lord, this is matter relating to cancellation of the tender, my lord. My tender.
Yes.
Two tender was floated.
Yes.
Two tender was floated by the respondent authority, my lord, for installation of the, my lord, bar lift at the Commandant Hospital at Kolkata and, my lord, BMC, my lord, Baliganj Military Cantonment.
For what?
For installation of the bar lift. Bar lift means, my lord, after dismantling of the old dilapidated lift, then new lift will be installed. That, my lord, two tender was floated, and in, my lord, first tender there was 21 lift, and in, my lord, second tender there was 26 lift. So, my lord, I participated in the tender, and I was successfully declared as a lowest successful bidder or L1 bidder. My lord, by later dated 21st December, I was intimated that my bid has been accepted. That is, my lord, at page 23, my lord. Page 21, my lord. Page 21 for the first tender, and page, my lord, 23 is for the second tender. That is, my lord, page 21, para 2. On behalf of the President of India, I hereby accept your tender as amended subsequently by later under reference for work mentioned above at the item rates contained in the sum of Schedule A for the amended contents sum of rupees 5 crores 43 lakhs 30,000. That is, my lord, my first tender. And, my lord, second tender, that is page 23. That has also been accepted, and it has been declared accepted, and for the contract sum of rupees 5 lakhs, 5 crore 4 lakhs 25,000. Then, my lord, as per my lord terms and condition, my lord, I have deposited my lord 5% BG that for the two my lord tenders, that is my lord near about 56 lakhs through FDR my lord to the nationalized bank according to the term. That is not my lord disputed at all. Then my lord, a integrity agreement was executed, which I have signed, which I have uploaded. And my lord, that integrity agreement, that is my lord voluminous, I have not my lord annexed here with because my lord
There is no arbitration clause.
Yes. There is arbitration clause. Well, yesterday I have mentioned it that although there is arbitration clause, it is not a bar. Where there is a parallel exercise, where there is arbitrariness, where there is illegality, irrationality, then court can interfere in under Article 226 of the Constitution. My lord, I have protected by the judgment also. My lord, if my petition is challenged only on the sole ground of that maintainability that there is an arbitration clause, my lord, I will come on that. My lord, here, my lord, the cancellation is on the actually, my lord, cancellation.
There is a cancellation.
Cancellation, my lord, I am coming. Cancellation. My lord, basically, my lord, cancellation is a non-speaking order because my lord, there is only word that you are a defaulter. And my lord, without giving any opportunity, without any show cause, just only word you are a defaulter. What defaulter? My quality of my materials, or there is a delay, or there is nothing
Where
has.
is the cancellation note?
Cancellation letter, my lord. That is my lord page. Both the contract, my lord, has been cancelled. Cancellation letter is that is page 69, my lord. Page 69 onwards, but that is page 70. Page 2 is page 70. In spite of notice issued to you under the above mentioned reference in connection with the work to be executed under the above mentioned contract, you fail to proceed with the work with due diligence. That is the next para. Therefore, I, accepting officer of the contract on behalf of the government, acting under the power vested in me in terms of the condition 54 of the general condition of the contract, and without prejudice to any other right or remedies which shall have accrued or shall accrue thereafter to the government under the terms of the above said contract, hereby cancelled your contract on account of your default. Which default, my lord? That has not been declared. On account of your default, and the said contract shall stand cancelled with effect from 10th September 2025. Now, my lord, the second part, para 4. I have been debarred, my lord, to participating in the further tender. Now, please note that, my lord, please note that the work as defined in the contract condition 1 of the general condition of the contract will now be got completed by me through other agency, and the performance security, that is my lord, performance security, that is my 5% security deposited, and retention money up to the last paid arrear shall be forfeited. In addition, all tools and plants and your materials lying at the site shall be confiscated by government and shall be absolutely at the disposal of the President of India, and no compensation whatsoever shall be allowed to you by government. Also, your farm company, including farm companies where proprietors, partners, director are working as proprietor, partner, director, shall also be debarred from participating in the tender for the balance work of the contract. So, my lord, two things coming here. One, my lord, I have been debarred. My security money will be forfeited, and my lord, non-speaking order. My lord, without giving any opportunity, without any show cause notice, my tender has been cancelled, my lord. Now, my lord, assuming, my lord, that the authority concerned has cancelled my contract only for the reason of the delay. Now, my lord, the point of adjudication, how the delay has been caused. Admittedly, the time limit which has been framed in the contract, that has been expired, my lord. I applied for the extension that is pending. I will come to the document itself. Now, they will try to demonstrate that the latches is on our part, but I will show your lordship that no, the latches has been, or the time limit which has been expired, my lord, for the other reason. So now, my lord, the integrity agreement, which I have not annexed, my lord. It's a voluminous, my lord, 2 integrity agreement. Page 213, my lord, of that.
You are appearing for whom?
Well, the respondent.
How you can debar without the due process of law?
Well, I will reply to all.
So show me the.
My lord,
you issued the so cause
lord,
notice before
that, my lord, kindly appreciate, my lord. My lord, this is kindly appreciate first that this is my lord, the installation of lift in command hospital and my lord, the other in the tough view, my lord. Now, my lord, the lordship knows very well the essentiality of a lift in a hospital. And my lord, on the urgent basis, this contract was given to them, and my lord, the period of work is for 180 days. My lord, I have a chronology of list for my lord's
No, I fully appreciate
My lord,
with you
show cause
regard
was
to-
given. Show cause.
Show me the show cause issued by you, giving an opportunity that you will be debarred from the.
That is the reason, my lord.
That
Kindly
is the only you that you satisfy this court. I am not on with regard to the cancellation of the tender. Only this court is entering the writ petition on the debarment. Whether that you have followed the procedure or opportunity of hearing.
Just a minute.
That is a settled law now. Show me that.
Yes. But there are several letters, and I have
No specific. You the show cause. If the show cause is not given, you will be debarred. Show me that. Maybe several notice contact. Once the agreement starts, the contractor started writing. The engineers started writing that so many communication. But you show me the communication where you have given an opportunity informing that he will be debarred. That is the only thing the court want.
no, just a minute. Show cause given on 21st of August. Just a minute, my lord.
Kindly allow me to satisfy your lordship the other form.
No. 9th August 2024.
That is not, my lord, before debarment. Kindly see, my lord. That show cause notice is different. I have been cancelled. कभी cancel करा हलो? 10th September 2025. My cancellation.
Series of reminder. And my lord, already 1.5 years has passed. The existing lift uninstalled in the month of April 2024.
Cancellation in, my lord, 10th September 2025. And that show cause notice was, my lord, issued before, my lord, even allotment of the work. Most probably.
Now you are in December.
Yes, where is that? There's nothing.
But now you are in December, Malad. There is a remedy before the arbitration.
That arbitration
Malad,
is different.
kindly see, Malad.
That's why I'm telling. I am not entering with regard to your allegation of completion of the work, cancellation of tender. This court is only on the last point. How you can debate without following the due process of the
Malad,
court can
so far as-
invoke the jurisdiction if this court found the
Now,
natural
Malad, the
justice
kindly
has been
consider
violated.
that clause 54 of the contract deals with the termination.
Correct.
Now, Malad,
I
before
am again telling you, sir, I am not asking any question with regard to the termination. I am only on the point of debarment of the petitioner from the contract in terms of this letter. Where is the notice of the show cause given an opportunity?
Then,
Show
Malad,
me.
then, Malad, may I come back with a report, Malad?
Yes,
Getting
come.
all the documents.
Show me is exact. You have given an opportunity, giving that you will be debarred. If that notice will be not there,
No, my lord, so far as my lord, the debarment on future contract is concerned, my lord, that is within my lord, the clause of the contract.
Clause of the contract, but you have to give an opportunity. You cannot monopoly, you cannot do. For 54 provides that. And where is your mention? You will act in accordance with the 54.
No, my lord,
You have relied upon this notice 9th August.
my lord.
Correct. You show me this 54, you will say that as per the section clause 54, you will act.
There are three parts in this particular my lord, writ petition. Number one, termination of the contract.
Correct.
Number two is the debarment for
Correct.
future contract.
Correct.
Now, my lord, so far as the termination part is concerned, my lord, there are my lord, some of the factors to be considered.
Sir, that's him again and again for the last 10 minutes. I am telling this court is not asking any question from you with regard to the termination. Termination, I will decide, let he satisfied.
Yes,
I am not satisfied till now with regard to the termination. In the open court, I am telling that. Only I am agreed with your action with regard to the department, whether you have taken appropriate step before the department opportunity. That is the only thing.
Then, my lord, kindly give me time, my lord. I will
When?
come with a my lord, within a week, my lord, kindly give
So I am staying this department order.
But so far as the department order is
Department,
concerned, my lord.
department
Fresh
order I am
tender
doing.
has been issued, my lord. Fresh tender has been issued, my lord.
Maybe that is different thing. I am staying the department order.
Only department person, my lord. Yes.
The petitioner has filed the present writ application being agreed with the impugn communication dated 10th of September 2025, wherein the Chief Engineer Headquarters, Kolkata Zone has cancelled the tender awarded in favor of the petitioner and also passed an order for department, also passed an order by debarring the petitioner from participating in the tender for the balance work of the above contract. This court has categorically made a query to the non-advocate appearing for the petitioner and petitioner and query from this has query from the respondent to show whether any opportunity of hearing or any show cause was issued to the petitioner before passing the order of department. Full stop. The learned counsel appearing for the respondents have shown the communication dated 9th of August 2024 and submit that this is the notice issued to the petitioner before the issuance of the impugn communication dated 10th September 2025. This court perused the communication dated 9th August 2024, but this court did not find any statement or averment that any opportunity was given, any intimation was given to the petitioner that the petitioner will be debarred from participating the balance work of the said contract. Considering the above, this court find that the order of department issued against the petitioner is in violation of natural justice. Accordingly,
prima facie, my lord, finding.
Prima facie, this court find that the department order of the petitioner for participating in the tender for the balance work of the contract work is issued in violation of natural justice without issuing any so cause notice and without giving any opportunity of hearing to the petitioner. Accordingly, the order of the portion of department wherein the petitioner the portion wherein the petitioner have been debarred for participating in the tender for the balance work of the said contract has been stayed till when you will available. 17th.
17th.
till 17th of December 2025 or until further order, whichever is earlier, let the matter appear on
So
17th.
far as the other part of the is concerned, that can you
bring-
I will, the remedy lies before the arbitration. Kindly make an observation.
I will hear, that I will hear.
File টা দিন।
Next.
ঠিকই ওদেরকে বললাম
Says come. Where is the list? These are the list. This. এই তো না? Yes, Mr. Paul.
Yes, sir. Yes, sir. Yes, sir.
So you are having the criminal matters or civil matters?
Sir, criminal matters, sir. Quashing petition for criminal matters.
Criminal matters. Criminal
Yes, sir.
matters.
Yes, sir.
Okay. So, so you want any advocate from the legal aid?
Yes, sir. Advocate Meet Guha Roy. Advocate Meet Guha Roy is a panel advocate.
What is the name?
Meet Guha Roy.
Meet Guha Roy. He is here.
Yes, recently he appeared for NCPT bail for in my case.
So he is having the name in the list. His name is not available.
Okay, sir. Then you can appoint any other advocate, sir. No issue.
No, his name is not in the list, sir.
Okay. Sir, he appeared in the month of September, I think. October, he appeared on my behalf as per the direction of the Honorable Supreme Court in an NCPT bail matter.
Meet Guha Roy.
Yes.
Meet Guha Roy. Yes. So I am appointing him.
Yes, sir. Sure, sir. Because he is well conversant to the facts of the matters.
The petitioner has filed the presented application praying for appointment of legal aid counsel on behalf of the petitioner for taking appropriate steps for preparing and for drafting and filing an application for quashing of FIR number 121 of 2024 within bracket PS Aberdeen, FIR number 55 of 2023 within bracket Campbell PS Campbell Bay, FIR number 29 of 2025 within bracket PS Baumflat, FIR number 47 of 2024 within bracket PS Diglipur, FIR number 49 of 2024 PS Diglipur, from FIR number 3 of 2022 at PS Mayabandar, CR case number 8 of 2022 pending before the Nunnet Judicial Magistrate First Class 2 Court at Port Blair, GR case number 1055 of 2022 pending before the Nunnet Judicial Magistrate Court at Port Blair. This court has called for the details of the names of the advocates of the legal aid panel. Mr. Mr. Meet Guha Roy, 33, MIT. Meet Guha Roy, having phone number 9903 004 having email address, is appointed as a panel advocate to defend the case of Mr. Manoj Paul before the before the learned court at Port Blair, as well as the circuit bench, as well as the High Court at circuit bench Port Blair.
Sir, to file quashing petition, just to file quashing
Yes,
petition.
that
report, sir.
already recorded. Only for filing petition.
Yes, only for filing quashing petition, filing and arguing.
Not to appear.
Yes, to appear, file and argue, sir, both.
For the appropriate court. In WPA number so disposed. Yes, disposed of. Mr. Guara has been appointed for filing application and to appear on behalf in respect of the above case which you mentioned.
For quashing petition, sir, for quashing.
Yes.
Thank you, sir. Thank you, sir. Thank you, sir. Thank you.
Next.
Well, I appear for the petitioner in this matter.
Yes.
The truck of the petitioner was intercepted, detained. It was carrying jaggeries. The materials were sent for test.
So I have gone through the report.
Report has been given. I have taken exception to the said report. Let them place the report, not then I shall be.
Where is the exception? Filed.
Yes. It is supplementary. Exception ta kotha. It's supplementary na.
Yes.
Yes, madam. But I filed the report on the previous occasion. But I just hurriedly, my lord, the incident happened on 15th
September.
15th September 25.
Yes, my 15th September. Initially, it was sent to one private lab. Thereafter, the government lab. According to the government lab, has clearly held that this to be a molasses. Government lab has said. And there was some confusion as regard to the report of the private lab. Second, a report was forwarded to the learned district magistrate, where we were cautioned that we should not have left the accused person who was the driver who was caught, he should have been at least bail, because it's a non-bailable offense. He should not have been released by us. So warrant has been issued to me. My lord wanted to satisfy that this person's name is coming up or not. My lord would kindly see the first instance, page 13. So just the concern.
Page 13 of the report.
Yeah, it is page 13 of the report.
That is in Bangla language.
I'm tender apology, my lord. I tender apology. My lord, kindly come to the next. This was next page 14.
Yes.
I tender. But this is the detention memo. My lord, this is the things we have detained: weight measurement, bill supply. 3 is very important, my lord. Road challan of the enterprise. He was the consignor. Who has come before my lord? 4, the registration vehicle. The vehicle. My lord, the last.
Page 14.
Page 14, last 1, 2, 3. My lord would find the road challan dated so and so of the enterprise.
Yes.
The enterprise is the petitioner before my lord. 4 is the Xerox copy of the registration certificate. The vehicle is in the name of the brother of the petitioner.
Yes.
My lord. Now, my lord, the detention memo, the second is 15 page, is in respect of the concerned person. His statements. Now, he was released, my lord. Now, my lord.
Who released?
Page 20, my lord, kindly come to page 20. This is the, my lord, this has been relied upon by my learned friend heavily. Page 20. But this was the first lab report. But according to us, this percentage actually qualifies for molasses. But what is the observation? But the last 2 lines. Received all labeled samples, 0.3 in total in good condition and seal contact. As per analysis, all samples looks like jaggery. But this was a statement. It does not say with some conviction that it is a jaggery or not. But thereafter, in the meantime, we had already sent to the government laboratory. What is the report? Next page, page 21.
You tell me,
what
is the procedure you adopted for sending the samples to the...
we had taken it from the...
What is the procedure? What procedure you adopted?
But that is as per the CRPC search and seizure. Now,
Correct. See, if it is seized, if you are telling that it has been sent to,
but it was seized.
sent to the page 20,
My lord.
that is with regard to the IFB, Agro Industries Limited. Correct.
Yes, my lord.
So once you have detained the vehicle, you found that is something illegal things are there.
Mm.
You have some doubt.
Mm.
So you have to take the sample in presence of the independent witness or independent. Okay, leave aside the independent witness in the officers. There is a procedure for sampling. How much quantity you have taken and where is the procedure. Then you have to send. So show me the first inventory and second inventory whether you have taken the sample and sent to the authority.
But what I have on record, my lord, because today the criminal court had taken cognizance of it. My lord,
I am not on that.
My lord, I have understood. My lord, page, this is page 17, my lord. I have sent the request for the chemical analysis.
What you released? Namely, after
My lord, release. But this will send to the, this is the person concerned, the driver who was released. But the next page is the, my lord, kindly see. I am sending here with 3 representative samples marked as A1, B1, C1, suspected to be molasses, drawn on 15 September in connection with detention of the vehicle bearing number so and so.
Yes.
Bearing number so and so, containing so and so. SIA was for necessary chemical examination at the existing chemical laboratory of your unit, which is well equipped for molasses testing. Now, Mala, synopsis and the sample. I have given the detail. Name and address of the person from whom samples taken, place of sample taken from, thereafter the date and time, thereafter description of the seal and wax, contravening section. Thereafter, the next page is where I have sent it to the government laboratory. Would advise of the samples dispatched to the chemical examiner, to the government of West Bengal.
Where?
Next page, page 18.
No, this is page 17.
17 is to do IFB.
IFB.
This is a private organization.
Correct.
My next page is the government authority where I have sending. My lord, kindly see, to the chemical examiner, to the government of West Bengal, so and so.
Correct.
The undermentioned samples have been sent to you by passenger train post register for beer securely packed. My lord, this was dated on 18 September and they were received on 19 September. My lord, dated excise officer, sign is 18 September. Excise officer, and it was
yes, 19 September.
19 September. My lord, so my lord, simultaneously within 3 days I have sent it. Now the first, the details of the report which I have got by the next page. The details.
So
My lord,
that's why I'm asking you.
Yes.
Page 17, you have given the total description sent to the IFB Agro Industries. No problem at all. Correct. This is the sample you have taken, you sent. Now you are relying upon 18. How the 18 has been sent?
Next page, kindly.
Correct. Next page. How
19.
the sample? Which sample you have sent?
I have mentioned 19. Kindly see description of samples.
19.
19.
Yes.
Would find the numbering in the 17 A1, B1, C1. Now, one plastic jar is filled with suspected to be molasses.
Yes.
1.5. So, this 2 A2 to one plastic jar filled with suspected to be molasses. This was sent. There is no dispute. But we have given the report also. They have not disputed. They have not come back at that stage. Now, my lord would find kindly come to page 21. This is the government's report. My lord, the fourth line, it is opined, the opinion. For third line, in between the bracket, that the contents of the said exhibits marked here, so and so are molasses.
Correct.
So it has been found to be molasses. Now, just some literature, because my learned friend is also relying on this, page 31. This is the percentage on the basis of which, it starts from page 21. It is the Indian standard specification for cane molasses. 28, but this is, would find Roman 3.
Yes.
in page 31 subject to calculation, total reducing matter as inverted sugar percent by mass minimum. So minimum it has to be for grade 1 50%, for grade 2 44%, and grade 3 40%. And my lord, the jaggery also I have given 52, that is 51.
51 page.
Yes, my lord.
Yes.
Oh, so my tender apology 54, my lord, that is a tender apology, my lord. My 53 is stats. What is the percentage? That would be, has to be there for earmarked for jaggery, my lord. 53, my lord, the standard, India standard, but what is the document? Cane jaggery specifications. My lord, Roman 2. Reducing sugar percent by mass, maximum 10%. Now, my lord, kindly.
No, which page 54?
Yes, my lord, 54 Roman 2. Yes, my lord. Reducing sugar percent by mass, maximum.
Correct. 10, grade 10 and
10, 20. So for grade 1, maximum is 10 and maximum. Malad, in the IFB report, the percentage was more than 77.
Yes.
So Malad, it was always, Malad, with deepest respect, it was always. Now, Malad, procedural 57.
Yes.
Oh, 57. Malad, we send these notices to the driver. First, 57. Next, this concerned person, 58, to Monojit De.
Yes.
And third is Arijit De, who is the owner of the vehicle, his brother. And the, my lord, the 60 is the person name, is the who was the consignee of the goods.
Yes.
Now, man, this is the Caesar report, which my lord wanted to show.
Yes.
61, 62.
Yes. Then.
And my lord, 61, just one thing I want to show. My lord, this one bill supply, my lord, this is in the middle portion, one bill supply, the name of the petitioner. Why? Because my lord wanted to know whether the name of the petitioner is there or not.
Okay. Next.
Now, my lord, next 63 subject, my lord. Second line, my lord would find this is the name of the person, the consignee. First line, Ghosh Bhandar. It was the consignee.
So now you are reported to the London magistrate.
Magistrate. And magistrate has
before the magistrate.
Yes.
What is your prayer before the magistrate?
Well, the magistrate also to take steps.
Caesar may kindly be accepted and may kindly register the provision West Bengal Madrasa. Yes. Then
my lord, magistrate pass. My lord, here also the name of the consignee is there. Consigner is there. Consignee. My lord, I had shown this order, but here only name of Ghosh Bhandar was appearing. So my lord said whether his name is appearing anywhere. So in the report also I have given his name because he was the consignee. Everything started from him. This is the statement. Now a warrant is to be issued against the driver. This is the direction. I would find the last page of 68, 67 and 68. Last 4 lines. 67 and 68. Strictly caution to act in accordance with law. Production before matter. The court has no but to issue warrant against the accused.
Yes.
I'm grateful, man. And this is, my lord, we have given documents that this is not the first time. Malad, there has been repeated occasion. This particular vehicle was used. Malad would find that from page 75. Page 75.
Yes.
Malad, kindly see the second line. That same vehicle today in question. Malad, the next page, Malad would find 76. Fourth paragraph. The scrutiny of the documents obtained from the travel revealed that owner of the truck is Arijit De and had been loaded approximately 300 tin containing molasses with a total weight of so and so. And the owner and supplier of the molasses is the proprietor of the enterprise.
Yes.
Monojit De, and the same is being supplied to so and so. So this is not a case in isolation, Madam.
Yes. Yes, sir.
But
just
very
the
outset,
226 is not maintainable once the cognizance have been taken.
but I had taken the point of jurisdiction. But it is a matter, my lord, where they had referred the matter for testing according to their own report. If your lordship kindly look at their own document, that this was not with me, but they had highly recommended that this particular article should be tested by IFB. And what they have written in the said letter addressed to IFB, lordship will get it from their own recommendation letter, that IFB is well equipped in testing the above articles. IFB is like at page 17. If you lordship kindly see the recommendation, first of all, the truck was intercepted. Thereafter, materials were taken with the signature of the driver, and that was sent to IFB Agro Industries Limited. And what is the recommendation? For necessary chemical examination, the existing chemical laboratory of your unit.
Before proceeding further, I am giving two options to you. If you want the disposal order from this court, you can argue the matter on merit. No problem. I will hear and I will pass an order. Another option I am giving, if you want to withdraw and go before the magistrate and pray for the release of the vehicle and take appropriate action.
Well, I am not an FIR name person.
Maybe, but what you are praying for?
I am praying for return of the goods and return of the articles.
Once the court has taken cognizance, it has been sent to the court.
But
you have to file an application.
But it is a fraud on the statute, fraud on the power. Lordship will kindly look at the letter they have given at page 17. They have written it to the IFB that you are well equipped, and this IFB is not a new one.
Now, after receipt of the report, they found it is a molasses.
That report, Malad, is come.
They have already intimated the seizure intimation to the magistrate. Magistrate taken the cognizance. Now it is up to the magistrate. The writ court cannot say the vehicle is to be released under the I thought for earlier the.
But if your lordship finds on the face of it that the goods have been detected to be not molasses,
You argue the matter before the magistrate. If that's why I'm asking, I am not. You argue matter, I will take the matter, and then I pass appropriate order on merit. If you want the chance here. But if you want the vehicle or the goods is to be released, you go before the appropriate magistrate where the case is registered.
because the goods have been detected to be not molasses by the appropriate authority.
Satisfy before the. That's why I'm telling. If this court will make any observation, then it will be very big problem to you.
I know that. I know that, Malad. That has been gone to the criminal case. Malad, maybe to be mentioned tomorrow. I shall speak to my client, Malad. I shall come back tomorrow.
Sure. Thank you.
To be mentioned tomorrow.
I will not be there for some person. My junior will be there. But with an understanding, hearing will not be there.
No, hearing, if you want to argue on merit, then we'll fix the matter. Tomorrow I will fix the on
And not on Monday, my lord, subject to my lord's
Not tomorrow, not tomorrow. I am fixing on Monday.
Tuesday, my lord, Tuesday.
Let come on Tuesday.
Tuesday to be mentioned.
Learned counsel for the state has concluded his argument. The counsel for the petitioner prays for time to take instruction. According case adjourned, let the matter appear on 9th of December under the same heading.
Not the same, to be mentioned.
Under the heading to be mentioned.
To be mentioned. Let us come back with the instructions.
Take instruction.
On Tuesday.
I'm grateful, my lord. I'm grateful.
since it was challenged to the NPA and no SURFACE Act is involved, so his lordship released the matter at 1 p.m. today. The urgency is that there was a subsisting interim order till today where they said that they would not take steps to issue a 13-4 notice. But could I humbly beseech your lordship to kindly include this matter as to be mentioned, because your lordship otherwise has the residuary determination. But only for the interim order may it be extended there. But we are mentioning upon notice. We shall once again give notice. But if there could be a supplementary list, and my lord, if we could come back at 4:30 or whenever.
Appellate side matter.
Appellate side matter. If we could come back at 4:30, my lord, subject to my lord's business permitting. Only the interim order be there because they had given an undertaking. We are carrying that order as well. They are carrying an they are giving an undertaking. Last line kindly sees that they will not in the meantime take any step. Because if they issue the 13-4 in the meantime, then they'll take the point its writ is not maintained. But that is not our case.
Yes.
It was till today, man. At 1 p.m., his lordship was pleased to release it. So I could not have mentioned in the morning as well, my lord.
कितना बजे? ये बता original side है ना 3 बजे से?
No, appellate side. Appellate side. For inclusion, file would be in court.
Appellate side will be over by 3 है 3:30 है 3:30.
But the file would be in court 24. We shall try and my lord, get it, but I am not too sure whether I will be able.
3:30 में supplementary कर.
ফাইলটাকে চেষ্টা করছি আনাতে 24-এ ছিল একটার সময় রিলিজ করে চেষ্টা করছি আনা চেষ্টা করো
But whether the order is
his lordship specifically directed his lordship's recording officer that it should be there in the server by 2. We checked just now, it's not there. I hope it would be done.
Unless it is not, then the file will not come here. That is
yes. So we are constantly
okay 3:30 रखो देखेंगे.
Great.
Just respond to
You mentioned.
what's that?
Yeah.
Section 2. Yes.
Provision for including residence and medical attendance. Residence is part of
Where? To be includes the provisions of food, clothing, residence, and medical attendance.
And treatment.
Yes.
So the taxation law will get law will have overriding.
Yes.
There is no provision in the act whether directly eviction apart from the specific law where whether the if the
23.
has a right.
Correct.
So for eviction, this is in the act. Section 4 can be section 4. Can be shall be expected under section 5 case of parent or taxpayer against one of those child against other
The obligation of the is extended to the customer. So that the children the obligation of the to the needs of such parents, the father or mother of as the case may be, so that the parent can lead a normal life. Well, more is not so relevant. Any person having a relative of senior and having sufficient shall maintain such things, provided he is possession of the property of that senior, or you inherit the property of that senior. This gives the right to vote.
Correct. So that's why any person being a relative or senior citizen having sufficient means to sell, he is in possession of the property, such senior citizen or maintain inherit the property.
Yeah, but unless there is a way executed, the son should normally inherit the property and the
Correct.
section 20. Section 23.
Yes.
Where any citizen has the right of property measured out of an estate and such estate or part thereof is transferred. But this transfer has been explained by the Supreme Court, not only transfer of property, but transfer of any interest. So let's say the right to the enforced if the transfer is but not against the transfer. The mother is not receiving any land for the portions occupied by the sons, even for commercial purposes. Just facts I wish to remind my lord. One, the plight of my fact is narrated in section pages 6 to 8. I'm not going to pages 6 to 8. First, the surgery was conducted in Odisha with the help of a she comes back what she faced.
Page
6
of
my request. First, 1050. 1050. The surgery is being held in Calcutta and all that. Then Roman 12 at the bottom of page 6.
Yes. Just a minute. This is affidavit.
Say how she landed in Odisha and where the surgery
Page 6. Page 6.
Page 6, Roman 12. Upon returning to Vietnam, that is after the surgery, Calcutta Sharma, compare your petitioner to all the household. He has to do for himself, wash clothes at the age of 7. He was very difficult for a weak and sick ability to manage things by going up and downstairs. Persistently for the first segment. Next week, Peter and provide hot water and cold water and take bath in cold water. That is why she often suffers from first cold water. The petitioner is not caring, she has been provided with a caring treatment. Right? Whenever the caring is not functioning, cancer is not having care, he even sends the caring
So you tell me this premises is being used for the commercial purpose. Correct. And he is residing? He is residing?
He is residing in the
first floor.
first floor. The entire second floor may be wrong.
The ground floor is the business premises of the one of the brother who filed the writ application.
Yes.
And he is also in the premises in question.
First floor.
First floor. First floor. Ah. Respondent number? Second floor also occupied by the respondent number 5. First ground floor and
First floor by the
Hmm.
one room was meant for
So you required that one room or the total building?
She was saying to me, to be honest, Sudha, now that my husband is not here, I to be able to maintain myself properly, I need a rent from the ground floor. Why no first objection was filed? Why not? Because they are having super there.
So that is the thing. See, court has to see. Yes, balance is to be seen. Now the court has passed an order for eviction. Till the eviction is they have not been evicted, they have to pay the maintenance.
But with that maintenance, will I be able to add a domestic help for instance?
No, that's why. So maintenance till the that has not been vacated. So that's why I'm asking if suppose I dismiss the petition and allow your petition. So what will happen?
I'll be able
Because
to
they are running the business on.
rent out the ground floor.
But they are running the business.
Then they have to tell a portion of
So why you're not settling? You required
why I'm not settling my predicament, my client will be clear for the paragraph given as which I
no that I appreciate, but what would the effect? What would be the effect of the eviction?
came back after the salary to settle that, but it became impossible for her to live on. A woman of 75 with all elements, diabetes.
So there is any premises of the so that she can be accommodated and she can live
She is
peacefully.
welcome in this particular house. She was here all through. She was enticed by her sister to go to Katok and stay there. And this application was instrumentalized by the sister for the money. I'm not complaining about the money part.
Correct. So
And so far as her residence part is also, I'm not contending anything on
residence
that.
part, residence part, you are in the second floor, he is in the first floor.
And she had her room here. She was
Sir, whether she is
previous.
having a proper accommodation so that she can accommodate and the maintenance amount can be increased.
Yes, Lord, we are not
Increase and-
contending on that.
In the lifetime of my husband, money was not an issue because my husband was
Correct. That's why your husband was.
running the business.
He gave the power of attorney. I got the trade license and all this thing.
I have drawn my law the text to it, pages 31 and 32 of my letter slabs which finished.
But that is not decided by the magistrate.
Nothing has been
That is
decided.
not decided by no.
That for the first
Correct.
year.
So that's why that is up to you. You take. See, this is a family. This is a family. Now they are running the business. Your husband was running.
My husband's business. My lord will kindly read on one of these subparagraphs.
No, I am trying to, though the matter can be settled for once. If at all, that's why I'm asking again and again, if at all they have been evicted. It is not only the ground floor. It is not the order for the only from the ground floor. It is
The entire house, the sons
entire
should
house
vacate.
to be evicted, vacated. So if entire house is to be vacated, they are also the son.
Why did not the Darwin tribunal give legal? Because they created an impression before the tribunal that they are agree with the order. They have not
Never.
sought recalling of that order.
That's why, see, anyhow, the litigation, not my God. You all person has to sit together, come, bring your mother, sit together, have a discussion, go to the house, inspect. I will also, if you want, I will appoint the special officer. Special officer will go identify your place where you can reside for peacefully and having a good, so that the good space can be provided to you. And with regard to the maintenance, then it can be settled down to 20,000 or whatever it may be. Then it can be increased. The family mother is 85, more than 85 years. What is the age of the mother?
75, 75 or something.
What is the age of the mother? 75. What is your age? 60. So why you are not accommodated mother? There is a space. वहाँ पे जगह है. That's why I will appoint. If you say first you sit together, I will appoint a special officer will go and see whether the spaces is there or not. Then they can make arrangement.
I don't have any problem. I always said, even before the court, that the mother is welcome.
They tried to persuade her. She was not willing to.
That is the problem. That is
That's
exactly
why-
the
that's
problem
why
because she was
tell
persuaded
them-
by the sister to stay there.
Correct. So that's why either you tell your mother to come. If it says able to come to the court, let the court interact.
At least virtually.
Virtually no problem. Because if they say, then the commissioner will let they identified which place they wanted to give to the mother, so that she can decide peacefully and not there will be no disturbance.
She wishes has to live independently without dependence on her son. She has to be for the higher health. She can't pay for her accommodation.
Correct. Accommodation, I am telling, for your accommodation for a free access.
Domestic health, I have whatever.
Correct. So let it be identified by both the sons will there, which portion they are intending to allow the mother. He will allow some portion. He will allow some portion.
Where
problem.
mother used to stay, she will stay there only.
Correct.
There only.
Now she needs space for the.
Whether she was residing in the said house,
Yes, yes.
there is a space.
They would agree to request.
Okay, that's why let's see come. What she want further? What is the spaces that she wants?
Yes.
What space she want? We sort it out in the family. If suppose today I will dismiss their application, allow, then it will appeal and all these things.
Virtually, I'll try to bring her.
See, that will be
Eventually,
better.
she has to come to Calcutta. She was staying here.
If it
Let
is
her come here,
convenient.
not be in the clutches of the sister who are manipulating her. All these applications I can show before your lordship.
Okay, no
From
problem.
our bank
Okay.
account, not 50,000 is not withdrawn in a very short span of time after I put in the money and I've got not the withdrawals.
Every
But I-
The court is not going to that. Only the court want that your mother 75 years, she should be given proper care. And my sons are telling that they are allowing it to reside in the mother with regard to the maintenance. They are ready to that. I don't think there is any dispute at all.
Let her come, Lord, in person
She
before
cannot
your
come
lordship.
here.
আমরা পয়সা দিয়ে দিচ্ছি
They will arrange. They will arrange all this things.
we'll arrange for her
Coming
her to
here.
come.
Train ticket, aeroplane ticket, whatever. They will arrange and
But the atmosphere there was.
We want her to come out of the clutches, my lord.
what I know, once she will come, I will appoint the special officer and I will allow to go and let's see identified if they are ready to give that space, nothing else with regard to the maintenance. Let's see, say what is the
Whether gives a date, whether indicates virtually, I'll try to ensure virtually.
Not virtually, my lord. My request is, my lord, kindly ask her to come in person. My lord will kindly ask her that what's the problem.
no. What is she can travel?
Yes, yes.
She will have to be brought,
No, she's able to travel. I don't know.
My client was there at Cuttack. Lord,
Okay, I will
says
do.
that, yes.
I will allow that, let both the make necessary arrangement to make all the expenditure for bringing the mother to this court, the flight expenditure and all the residents of in Calcutta.
At present, I have told the other sister's house in Puttar. That is also near Puri.
What?
This is the whole lot difficulty is this.
What is the difficulty?
Where the case,
They are kind enough to
the matters are apparent.
kind enough to look after her year after year.
It is a problem. I could not go to as a mediator. Otherwise, I could have settled the matter within 5 minutes.
But your lordship can also, my lord, send it for a mediation if your lordship so desires. But for the age of the lady, I do not know, my
That
lord,
is the
whether it will be
problem.
hard.
That's why you want to interact the ladies so that your mother को बुलाएंगे आप देने के लिए जगह मैडम अपने मदर को रखने के लिए जगह देंगे प्रोवाइड करेंगे अच्छे से कोई तंग नहीं करेंगे correct so
it doesn't
and see you take instruction and come first I will take let's see come to virtual mode you tell her what is her actual requirement residence if they will what is the actual requirement for the residence what is the actual requirement for the residence and what is the actual requirement for our maintenance for per month let's see come with the problem. Yes sir, Mr.
Lordship. But the only thing, Lord, let her come. I am not bearing the expenses for her.
It cannot be a publication.
Correct. You live your independent kitchen, independent room, whatever it may be, independent relatives, independent friends, no problem. But settle the issue.
তোমার ক্লায়েন্টের কনভিনিয়েন্সটা
At the learned counsel for the respective
for the
parties.
date you ask your client.
This could find that
তারপর যদি বলে আমি অসুস্থ পয়সা পাঠালাম
petitioner namely Pushpa Sharma petitioner in WP PA number 10504 Srimati Pushpa Sharma is to be heard in person accordingly the petitioner Pushpa Sharma is directed if possible she should appear before this court in person ये महीना में कोई कौन सा डेट खाली है देखो 2 बजे दिसंबर में कोई डेट खाली है दिसंबर में कोई 2 बजे का खाली है 2 बजे 1 बजे तो खाली होगा
कोर्ट में लाएगा
1 बजे 2 बजे देखो इसमें नहीं है वो हम बोला कौन सा डेट में नहीं है 17 18 19 20 17 18 19 कैसा मेंटेन का डायरी नहीं है आज हम तुम लोग एक डायरी लेके देगा हाँ 16 दिसंबर 2 बजे पक्का श्योर 16 दिसंबर on 16 December 2025 at 2 p.m. If the petitioner is ready to come in person, confirm before this court in person, comma, the respondent, the sons, namely, the before this court to come is ready to appear before this court in person, comma, the sons, you will make arrangement only. The sons, namely, the private respondent number 5 and 6, being the sons of the petitioner, shall make necessary arrangement for bringing the mother the respondent number 6 shall make necessary respondent number 6 shall make necessary 6 shall make necessary arrangement for the mother and shall make necessary arrangement for the mother before this court on 16 December 2025 at 2 p.m. If the petitioner is not able to come in person, comma, she is given liberty to appear through virtual mode. Let it come. So, sit you up with the client, take instruction so that the matter can be solved.
If not section or use that particular instruction now, why we are not completing tender? First tender was cancelled. First call was cancelled. The second call I am apparently in A1. was also promised. Now we are only this particular, we promised it about. Comes tomorrow or on Monday, something. Your lordship told me this instruction comes as to why you are not issuing the letter of call. That is the only. Actually,
When? Learned counsel for the respondents press for time. The counsel for the petition submitted that the respondents may be directed to take instruction. Why, in spite the petitioner is the L1 in the tender process, comma, the authorities are not taken a decision till date. Let the respondents are directed to take instruction and and to inform this court on 8th of December 2025, list the matter on 8th December under the same heading. ঠিক আছে? Next. Election Commissioner, what is the matter about? Acha, your persons have been deputed on duty. Data. You are the data entry operators.
Case number 119.
100?
119, which is SL Visual Lordship. The notice?
119.
119. Notice of the district magistrate.
Yes.
May I read out my reference above in view of the preparation of the election personnel. Data for West Bengal. West Bengal Legislative Assembly election 2026. You are requested to kindly check and verify the office information and employee particular provided in the portal so and so. So I am challenging this. So I am a my lord employee. We are all the employee of a particular cooperative society bank. So my lord, it is the autonomous body, neither funded by either of the government, either central government or state government. So my lord, as per the requirement, as per the section 159 of the Representation of People's Act, that parameters are not satisfied. My lord, we cannot defeat in the election procedure. This is that is what I am challenging, my lord. My lord, there are series of judgment of this coordinate bench of this Honorable High Court also.
Yes, madam.
Your Lordship, in this issue, a matter went up to the Supreme Court from state of Gujarat, Your Lordship. And the Supreme Court had been pleased to pass an order. I'm handing over the judgment of the Gujarat High Court first.
You completed, not okay.
Now, my lord, may I hand over one judgment first? This AIR 1981 Supreme Court 1395. Here, my lord, kindly comes to page 4. The pagination, my lord, below, my lord. Page 4. Fourth line from the page 4, bottom, my lord.
Which paragraph?
My lord, last 4 line of page
4.
Page 4. My lord, pagination is.
Yes, page 4.
Yes, my lord, in last 4 line, my lord. In our opinion, the expression cooperation, corporation must in context mean a corporation created by the legislation. Here, my lord, this banking corporation is not created by the legislation and not a body or society brought into existence by an act of group of individuals. A cooperative society is therefore not a corporation established by or under an act or central legislation or state legislation. So that is the settled law, my lord. Now, my lord, I am referring, my lord, on the judgment of this coordinate of this. Actually, here, my lord, is particularly similar issue, my lord.
Yes.
My lord, page here is also my lord, page number 4.
Yes.
Yes, my lord.
Paragraph?
Paragraph 17 onwards. 17 onwards. Section 159 to written several authorities for the purpose of subsection 1, subsection 1 provides that such authorities shall, when so requested by the regional commissioner appointed under Article 324 4 or the chief electoral officer of the state, make available to any returning officer of such staff as may be necessary for the performance of any duties in connection with an election. The very mention of the Article 3 to 4 subsection Article 4 in section 159 makes it abundantly clear that Article 324, at least with regard to the limited component of the officer who can appoint it under said article, has to be read in conjunction with Article 159 of the Representation of People Act. Constitutionally, my lord, it is well settled, has to be presumed, in respect of the statute enacted by the legislature in its wisdom. Thus, it cannot be said that the Article 324 overrides the section 159 of the Representation of People's Act. Rather, a harmonious and a correct construction would be that the powers exercisable under Article 324 by the ECI are circumscribed by section 159 of the Representation of People Act, which is a specific statute inter alia for the purpose of conduct of election. Insofar as the person who can be appointed for the purpose of election by ECI is concerned. File number 80. No material has been produced on behalf of the respondent to show that the concerned bank is a cooperative society either controlled or financed wholly or substantially by the funds provided directly or indirectly by either central government or the state government. Rather, the respondent number 5. Here is the respondent number 7. Bank itself argued the contrary. Nor is the case of anybody. The respondent number 5 bank is a local authority. That is one of the, my lord, parameters under section 159. Or university or the government company as defined respectively in subclause 1, 2, 3 or subclause 2 of the 159 of Representation of People's Act. The remaining subclause of section 159 with the subclause 4 stipulates that the staff from any other institution concerned undertaking established by or under a central or provisional or state act or controlled or funded by the central or state government can be appointed for the purpose of an election. Thereafter, my lord, kindly come to paragraph number 23.
Yes.
Article 324 vested general power on the ECI under the authority of the Constitution. Request the governor of the state to make available to it such staff as may be necessary for the discharge of its function. However, in view of the discussion above, the same does not provide anything about the nature of employees and or the institution from which the employees shall be drawn. Paragraph 24, we do not operate in a totalitarian state, and as such, it cannot be held that the government has blanket power over any and every institution and concern or undertaking operating under the sun within the territory of India for any purpose whatsoever, unless so stipulated specifically in the Constitution or any specific law. For the limited purpose under discussion, thus Article 324 has to be read in conjunction with section 159 of the Representation of People's Act. Thereafter, my lord, all the previous judgment has been considered. Now, my lord, kindly come to paragraph number 31. May I read on, Section 159(2)(4) has been harped upon by the Election Commission of India. Therefore, the limited issue remaining to be examined whether the bank is one established by or under the central or provisional or state act. Even apart from the judgment cited by the petitioner, the discuss about where a distinction was drawn between an institution established under such an act, and other concerned registered or incorporated under that. It is evident that the present bank does not come within the purview of the same merely or by the fact that it is registered under Act 2006, that is West Bengal Cooperative Society Act. Here is the case is similar. It would be fruitful to refer section 24 of 2006 Act, which speaks about cooperative society which may be registered. In this context, subsection 1 of the section 14 of the Act 2006 Act, under which the respondent bank, respondent number 5, has been registered, provides that subject to the provision of the said Act and rules, a cooperative society established with the object of social and economic betterment of its member in their common interest, though through its self-help and mutual aid in accordance with the cooperative principles and facilitating the operation of the cooperative society, including a cooperative society formed by the division of an existing cooperative society by amalgamation, so and so manner. Now kindly come to page, paragraph number 34. Thus, establishment of society, even as per section 14(1), which is the provision for registration procedures with the act of registration. Hence, by no stage of emanation it can be construed that a society registered under this act, established by or under the central provision of state act. The establishment.
Okay, next. What are the other?
My lord, this issue is very much clear, my lord. I am a bank, my lord, an autonomous body, cooperative bank, self-financed, my lord. I am not getting anything from any state or central government, my lord. Not run by, not financed by the central or state government. So it is not coming within the parameter of section 159. Like in this case also, my lord, this notification was, my lord, withdrawn, my lord. Can you see the paragraph number 41? This is the proposition of law, my lord. Take down 41, my lord. We therefore allowed on this requisition allowed thereby setting aside the requisition and appointment of the members of the petition number 1 association working respectively in Malda district central cooperative banks and so bank respectively. Consequential orders shall be passed and due steps shall be taken by the respondent authority to ensure that the employees of the said banks are not recruiting for the appointment of the under representation of People's Act for the purpose of any parliamentary election or whatever election, my lord is. So my lord, this is my case, my lord. I seeking, my lord, quashing of that particular notice, my lord.
Yes.
This is my case, my lord.
Not similar question fell for consideration before the Honorable High Court at Gujarat. Similar judgment was pronounced. The Honorable Supreme Court has stayed the judgment. I'm not. This is one aspect of the matter. Please have a look at 159. Section 159, that it's quoted. I'll hand up the book.
बुक क्यों नहीं रखते? प्रेजेंटेशन ऑफ पीपल पहले ही बोला हम आपको, यहाँ में वो BNSS भी नहीं लेके आया है. Yes, section
159.
Yes.
Staff of certain authorities to be made available for election work. The authorities specified in subsection 2 shall, when so requested by a regional commissioner appointed under clause 4 of article 324, make available to any returning officer such staff as may be necessary for the performance of any duties in connection with an election. But probably as of today, my learned friends, cause does not arise for this, for invocation of 159. The following shall be the authorities for the purposes of sub-election 1, subsection 1, namely, every local authority, his case does not come under that. Every university, his case does not come under that. A government company, his case does not come under that. Now, please take the next clause. Any other institution, concern, or undertaking which is established by or under a state act. So, it not only conceived of an authority or institution created by an act, but it also conceived of an authority created under a state act. This point has probably not been considered by the coordinate bench of our court.
No, it is
that has been considered.
Under an act.
Yes, that has been considered.
By act, under an act. No, there is a gross difference.
By or under a central provision.
Or a state act. Or which is controlled, financed wholly or substantially by funds provided directly or indirectly by the central government or a state government. So all these are disjunctive. So if an institution is established under a state act,
yes,
then it qualifies for clause 4 under 159(2).
Yes. Yes.
Now please come to the two judgments, not the similar judgment passed by the Honorable Gujarat High Court, which has been stayed by the Honorable Supreme Court. Ashi, copy ashi, tomar kache copy ashi. Copy ashi. Oh. এটা একটু লিখে নাও, কস্টালটা লিখে নাও, ঠিক আছে, ভাবনগর ডিস্ট্রিক্ট লিখে নাও, হ্যাঁ ঠিক আছে দিয়ে দিচ্ছি। Please have a look at paragraph 33 straightway.
Paragraph
33. এটা কি হলো উল্টো কেন হচ্ছে এটা 32 এর পরে 32 এর পরে 33 36 what is this
Yes.
but the word control I'm sorry not please come to 32 the above position would mean not what is the election commission's power in 324. The above position has been reiterated by this court in Chief Justice of Andhra Pradesh versus so and so, which the court held as follows. It is thus now settled by this court that the term control is of a very wide connotation and amplitude and includes a large variety of powers which are incidental or consequential to achieve the powers vested in the authority concerned. The word control is also sometimes used synonymous with superintendence, management, or authority to direct, restrict, or regulate by a superior authority in exercise of its supervisory power. But I skip over not the discussion on the judgments. Please skip over 4 or 5 lines. Now, your lordship will be pleased to find the sentence begins from the middle portion of the line, the expression control.
Yes.
Again came up for consideration before this court in so and so in the context of Article 235 of the Constitution, and the court held that the expression control includes disciplinary control, transfer, promotion, confirmation, including transfer of a district judge or recall of a district judge posted on ex-cadre post or on deputation or an administrative post, etc. We are of the, not I skip over the rest of the paragraph. We are of the opinion that when we test the meaning of expression controlled, which figures in between the words body owned and substantially financed, the control by the appropriate government must be a control of a substantial nature. The mere supervision or regulation as such by a statute or otherwise of a body would not make that body a public authority within the meaning of 2HID of the RTI Act. But that's different. Then not paragraph 35. We are therefore of the view that the word controlled used in section so and so of the Act has to be understood in the context in which it has been used vis-a-vis a body owned or substantially financed by the appropriate government. That is, the control of the body is of such a degree which amounts to substantial control over the management and of affairs of the body. Then what the court goes on to discuss on what is a substantially financed test. Then please turn over to 38.
Yes.
Merely providing subsidiaries, grants, exemptions, privileges, etc. as such cannot be said to be providing funding to a substantial extent unless the record shows that the funding was so substantial to the body which practically runs by such funding, and but for such funding it would struggle to exist. The state may also float many schemes generally for the betterment and welfare of the cooperative sector, like deposit guarantee scheme, scheme of assistance from NABARD, etc. But those facilities or assistance cannot be termed as substantially financed by the state government to bring the body within the fold of public authority under section so and so of the Act. But there are instances where private educational institutions getting 95% grant in aid from the appropriate government may answer the definition of public authority. Considering the aforesaid observations and the law laid down by the Honorable Supreme Court, in the case of so and so of cooperative bank, and applying the same to the facts of the case on hand, more particularly with respect to petitioner number 1 District Cooperative Bank registered under the Act 1961, having a license under the Banking Regulation Act only for the purpose of running the business of banking and provisions of the Act of 1961 vis-a-vis the provisions of section 159 of the Act, more particularly section 159(2)(4) of the Act 1951, it cannot be said that respondent number 1 District Cooperative Bank is an institution, establishment or concern which is controlled or financed wholly or substantially by funds provided directly or indirectly by the central government or a state government. But this is exactly the same logic which has been employed by a coordinate bench of our court. Now, this judgment has been stated by the Honorable Supreme Court. But this arises from the judgment dated 28th April 2017 passed by the Honorable Gujarat High Court. But on 10th April 2014 judgment, 28th April stayed. Not the same position continues. Not what
So
I
it
most
is still can stay.
still pending. But what I most respectfully submit is not the Honorable Court was persuaded to go into the question of control test without the first phase, part of the applicability clause not having been employed or not having been argued. An institution created by or under the State Act. Now, your lordships, from time and again, 78 Supreme Court onwards have made a distinction between a body created by an act and a body created under an act. So, if it is a body created under an act, then it is obviously covered by clause 4.
Small reply. That's all. Anything?
Yes, that about not constitutionally under Article 51A, every citizen has a fundamental duty. But of course, we don't have to join the army for the purpose of performance of those duties. But these fundamental duties should be discharged by somebody else.
Yes.
Yes, small reply. First of all, this cooperative society bank is registered under section 14 of the West Bengal Cooperative Society Act. And section 134 says, my lord, may I read out this? A cooperative credit structure entity shall have the autonomy. Shall have, my lord, may I? That is different from this cooperative society bank.
Which?
My lord,
Which act you are showing?
my lord, West Bengal Cooperative Society Act 2006. My lord, section 134C, subsection 2.
Section?
134C, subsection 2.
Ah.
A cooperative credit structure entity shall have autonomy. Right? So we are not funded by anyone. There are
Not required.
self-finance.
Not required.
And second thing is, my lord, two things.
West Bengal Cooperative?
West Bengal Cooperative Societies Act 2006,
Okay.
section 134C, subsection 2.
Yes.
The second thing, my lord, reply to the, my lord, this section 159, subsection 2, clause 4. Reply to that effect, my lord. That, my lord, judgment I have cited, my lord, 1981 Supreme Court 1395, page 4. Or kindly read once again, my lord. What? The last 4 line. In our opinion, the expression corporation must, in the context, mean a corporation created by legislature. We are not a creature of legislature. We have been registered under a particular act. That is, I will show, my lord. That judgment of the coordinate bench also says so. And not a body, and my lord, not a body or society brought into existence by an act of a group of individuals.
Okay.
A cooperative society is therefore not a corporation established by or under an act of central or state legislature. Now, my lord, kindly see, comes to the coordinate bench judgment. Kindly come to page number regarding the control, paragraph number 25. Thereafter, I will place paragraph 35. Everything has been discussed. All the previous judgment was considered. Paragraph regarding the control. So the Reliance. The reliance placed by the Election Commission of India regarding Article 243Z and so is entirely beside the point, since those contain the general controls of the administration and control of the state over cooperative society. Such control does not automatically make any or every cooperative society and institution established by or under a central provisional state act. Now, my lord, kindly comes to paragraph number 35. Now, kindly come to paragraph number 35.
Yes.
Prior to that, 34 and 35. Does establish 34, does establish a society even as per section 14(1), which is a provision for registration procedure act registration. Hence, by no stretch of imagination can it be constituted that a society registered under the act is established by or under a central or a provisional state act. Now 35. The establishment of the society is not by an act. We have established not by an act. Central state governing cooperative society, but is independent of statute. Only after such establishment takes place, the registration which is required under section 2006 Act takes place. Registration merely subject to such society to the rules and the benefits of the statute. However, the act of establishment itself is neither by nor under the statute. So we are not controlled by any act. We are not. We are not established by any act, either state or central or provisional. We are independent establishment. That is why section 14 of the West Bengal Cooperative says that registered society may register their establishment. That is not section 14. Here, my lord, the coordinate base set aside this particular notification, and here this judgment I am relying that we are not established under any of item of the act.
Thank you, thank you.
This is my submission, my lord.
My lord, may I add? I'm for the bank. My lord, actually, 134C, kindly come to.
Which one?
134C, which my learned friend cited. 134C, under the West Bengal public side is there.
Yes.
My lord, PA, the state government subscription to the equity share capital of the profit credit structure entity, which this bank is, shall not exceed 25% of the subscribed share equity share capital. Means by the law, it cannot never have a majority share capital. So there is no question of this one. My lord, come to next this one, 3B. There shall be only one nominee of the state government on the board of the state cooperative or central cooperative or the rural development bank or this one. So the law itself prescribes that the government will not have the state will not have the control. I can come to the general body of the, my lord, well-known fact, the general body of the society or the bank based in the general members of the members or the delegates, and it is the body corporate. So I am not arguing on that. I am saying that by the law itself they cannot have the control. By the law, because
No, that's correct. No, that's why they are telling they are not coming under the control of any state or any central government's order. So the election commissioner cannot pass an order allowing the bank to.
that is also, I am the bank, and my lord, kindly come to the Article 324 of the Constitution. It should be governor and the president's. This one is there. No order can be passed for in respect of this bank by the governor of this.
Okay, thank you. Hearing concluded. बुक दे दो उनको. Yes, next.
Well, I'm for the.
Lordship, I am for the Union of India. Their service has been effected on DGFT or not, I am not aware. Whether service has been effected on DGFT or not, I am not aware.
It has been affected.
Upon whom?
DGFT, Director General of Foreign Trade.
DGFT.
That's the
Supplementary affidavit.
answer.
You are
Answering
referring to
response. Union of India, my lord.
Well, this is my affidavit of service. I have served them by hand.
So, my lord, I was suggesting that may I take instructions and inquire from the Ministry of Law also, so that the effective hearing can be done.
May I indicate what's the matter about, my lord?
Nah.
Yes.
The petitioner is a government of West Bengal undertaking. Is owned by government of West Bengal. It's a government company. Now, the central government came out with certain. The petitioner is the nodal authority for electronics industry. It assists the electronic industries in the state of West Bengal. It's a government body. Now, to assist one exporter, the petitioner 7 advance licenses, small, 1,30,000 licenses were obtained by the petitioner, and it was under a scheme called DEC, Duty Entitlement Scheme. Now, under which you can import the goods free of customs duty, and we have to fulfill a export obligation. Now, it was to be exported by a link manufacturer. He exported the goods, submitted documents with the office of the DGFT. Now, that was in the license of 1993. The documents submitted closed in 1998. After long 8 years, in 2006, a show cause notice was issued. Now, we appeared, then nothing happened. It was pending. Then in 2025, then they passed an order. The day show cause notice issued, same day order passed. No opportunity of hearing, nothing. So we came up with this honorable court. This honorable court said this cannot stay. Set aside. Department DGFT was directed to supply me the show cause notice and all the documents they want to rely upon in a particular given email. Court asked, you give an email, you say, I have not received, that will not do. You have to nominate an email here and now, and they will conclude within few weeks. Again, nothing happened. That was in 2017. In 2025, they start giving notice that a personal hearing is given. We write to them that you are supposed to give us documents as per the order of court. No reply, again date of hearing, again date of hearing. Then in one hearing, I personally appeared. There, the officer taking the hearing said that these documents are in customs, why don't you apply? I say, court has directed you to supply. And this is also the law that any authority issuing a show cause notice must furnish all the documents he wants to rely upon. Now, you give us documents, you see, our file is lost. It's 1998 matter, this 2025, nothing is available. Why don't you apply to customs? I will expedite with the customs. So we applied to customs. Please give us this export documents strictly without prejudice to our rights and contention as desired by the Director Foreign Trade. Now, after that, we receive an order from the Director Foreign Trade saying that Mr. Shamal Sarkar, he asked for time to obtain documents from customs authorities, and so the matter is adjourned peremptorily, hearing fixed on 10th of December. Well, that was totally a wrong statement. I was present in the hearing, and in fact, our letter to the customs, we have said that that this is without prejudice as desired by the DGFT. Now, today, my lord, after this order, my lord, totally taking a different stand, my lord, my client took advice and my client has been advised that this whole show cause notice has become stale. There is no limitation prescribed by the statute, but it has to be within a reasonable period. It show cause notice of 2006, were in 2025. Now, this 19 years cannot be a reasonable period. So the proceedings has lapsed. It has become stale, one. Two, the proceeding also violates the principles of natural justice because this honorable court directed them to supply the documents and they refused to give the documents. Without the documents, the hearing cannot be made. If their files are lost, it's their problem. They have to, if adjudicating authority must supply all the documents, that also they are not giving. Third, the authority who is taking the hearing, adjudicating authority, he himself is has shown a predetermined, preconceived mind. So that is why I am before your lordship, my lord. Now let me show me the document.
Where is the order?
Order, the 7th, my lord. Page 131, lordship. And before that, you should not take one page before, at page 129. This is our letter to customs. In fact, he said he will pursue with the customs. And now we gave all the details about the documents need. Then his order. At page 132, Lordship kindly sees paragraph 4. A totally different version. During the year, the above deficiency, the response reply was brought to the attention of the council, who sought reasonable time to enable him to collect and submit requisite documents, evidence after opting for the customs authorities. It totally
Yes.
And Lordship kindly sees the order passed by this honorable court at page 68. Page 68, operating portion at page 69. At the bottom of the page, last paragraph, page 69. In the facts of the present case, interest of justice is subserved by requiring the respondent author to serve the notice of show cause as also all the documents. Page 69, bottom, my lord.
Yes.
Lordship got it? Court directed them to serve documents. Now, my lord, 2014 Act देखो. But at the motion stage, I not trouble your lordship, but I must submit one document. I have to tag can. This 2014 one Supreme Court cases 156. 2014 volume 1 SCC 156.
Yes.
My lord. Lordship kindly takes up paragraph 15 at page 160. So far as the power of the governor with regard to review of an order is concerned, Rule 31 of the rules does not prescribe any period of limitation. In this case, also Section 14 does not pay any prescription. Normally, when no period of limitation is prescribed for exercising the power of review, the power of review should be exercised within a reasonable period from the date of the order which is sought to be reviewed. In the instant case, the governor has reviewed the order after about 5 years. In any case, period of 5 years cannot be said to be reasonable period. The action with regard to review of the order, so far as to make it effective, ought to have been passed within reasonable period, and the facts of each case would determine as to what period would be reasonable. In the instant case, looking at the fact that Rule 32, that was Rule 31. In another rule, Rule 30, the rules prescribe period of 6 months as limitation for exercising power of review in disciplinary cases. One can reasonably infer that period of 5 years cannot be said to be reasonable for exercise of power under Rule 31 of the rules. We therefore conclude the governor had power to review the order dated so and so, which pertains to dropping all the departmental proceedings against the respondent. The said power could not have been exercised after about 5 years, as by no stretch of imagination, period of 5 years can be said to be reasonable in the facts of the case. Now, Lordship takes up Section 14, under which they are exercising their powers. Section 14, Lordship kindly sees.
Section 14
of the Foreign Trade Development and Regulation Act. It's the small statute. The Section 14 also, there is no period prescribed
Yes.
for limitation. On which time? No order imposing. One of the has given notice of writing, informing the grounds and so and so. Then Lordship can takes up page 14, capital D.
Yes.
14. The Director General or an officer authorized by him may, by order, suspend or cancel license to import or export especially goods or services technology without giving the holder of the license a reasonable opportunity of being heard. But such persons shall be given a reasonable opportunity of being heard within 6 months of such order. So, my lord, a proceeding has to be concluded within 6 months. That is desire in 14D. I would say, on the interpretation given by the Supreme Court, for the purpose of section 14 also, the reasonable period is 6 months.
Yes.
Here it's already, my lord, 19 years have gone.
Yes.
So I was praying, my lord, Lordship kindly stay the proceedings pending before the adjudicating authority. And if they want to file affidavit, let them file affidavits. We'll satisfy your Lordship. If I succeed on this first point, my lord, no other issues need to be gone into. I have other judgments, my lord. I'll submit at the time of final hearing.
Yes.
My lord, kindly fix it next week on Tuesday or Wednesday.
Whether you're proceeding.
My lord, I have to take instructions, my lord. That's why I have apprised you at the first instance, my lord, because I want to assist, my lord.
So you tell your authority not to proceed till your what instruction you will
It is fixed on.
My lord, they don't rely on advocates' Lordship. Kindly stay. It will be burden for some for my client, for my friend also.
Kindly don't stay, my lord, this moment. Kindly fix it on a Tuesday, my lord.
It fixed on 10th.
I thought Tuesday I'm saying. Tuesday is not 10th, it's prior to that.
27 November we have served them, my lord.
Where is the 26th May notice?
26. This order itself.
Order, my lord, this day. Hearing is page 131. This is the order. On page 133, the next date of hearing is mentioned.
Correct.
At page 133.
10-12, the next date is there. 10-12-25.
Yes, my lord, that's why I'm saying, my lord. If it is fixed on Tuesday, this matter, my lord can dispose of. So there will be no requirement of any stay. Whatever may fall from the my lord, it will be better for the petitioner also, my lord. If it is matter is disposed of within a limited period.
Counsel for the petitioners has argued at length and prayed for stay of the proceeding pending the concerned authority. Counsel for the Union of India prays for time for taking approach.
No.
This could find that the schedule of hearing is fixed on 10-12-2025. Accordingly, the case is adjourned. Let the matter appear on. 9th को टॉप में तो नहीं है कुछ. 9th को टॉप में कुछ है. 9th of December 2025 under the heading adjourn motion at the top.
Well,
I'm dead.
The affidavit of service filed with the petition be kept. Take the book.
Lordship, keep it with the brief also. Better.
My lord, sometimes we face difficulty. We have been engaged for Union of India, who have been engaged for Director General. We don't know. We have to see all these things, my lord.
Lordship is granting short stay till the next.
Fixed on 9th.
12th, 10th is there. That's why 9th are fixed on top.
9th on the
9th are
top.
fixed on top. Let it see what is their context. If it is not there, adjourn. No. Urgent.
9th.
Urgent motion 9th at top.
9th is
Tuesday. Wednesday is the date fixed.
I'm grateful.
I mean, not very.
Sorry, eight.
I'm for the petitioner, Mr. Ranjan Kumar Kali, appearing in this matter. He is appearing on before court number 5. Kindly short pass over.
Lordship, then if the petitioner is not there, Lordship, then because actually, I mean, my learned friend is there, I don't know.
That agreement.
It's that agreement. What I find is he's challenged the auction without including the third party who is all the success.
I'm sorry, my lord, I have a matter.
Lordship.
No, this is the matter, my lord, where I have sought for, my lord, the renewal. Your lordship had the matter extensively, my lord. Again, my lord, to recapitulate the whole thing, my lord. My lord, the petitioner was allotted a shop room, my lord, in the BRS to run a cafeteria in the year 2019. Now, the initial license.
Cafeteria with you.
Lordship. In 2019.
I am telling all the cafeteria with you.
No, that is bookstall, my lord. This is a cafeteria, my lord. I haven't got the opportunity to go there.
Wherever you visit, you will be having a good cafeteria.
Provided, my lord, if they grant, my lord, the renewal, then I would be able to enjoy, my lord. Otherwise, my lord, this is the already, my lord, it is expired. Now, 2019, my lord, the original allotment for 11 months. My lord, time to time, this has been extended. Now, my lord.
When the last extension?
Last
January.
extension was given, my lord, 1st January 2025.
19 to
and 30th November, that has ended. Now, my lord, during this interregnum period, my lord, I have sought for renewal. On the ground, my lord, that renewal, my lord, that will now in my renewal application, they have passed the impugned order at annexure P8, page 49.
49.
Yes. Well, they refer that policy your lordship knows, my lord, that 2018 that has been introduced.
Yes, no extension can be granted.
No extension can be granted. But this is the one line, they have made up mind. My first limb of argument, they have proceeded with a closed mind. Now I will show to your lordship, my lord, the license agreement contain a clause for renewal. Clause 6. But they are, my lord, and they are oblivious. It is not that, but they were not aware of the fact at that time also the policy has been introduced. But they are very much alive to the fact that there is already a existing policy, because the original license was granted to me in the year 2019 allotment. By that time, my lord, the impugned policy, my lord, is already, my lord, surfaced. Now, after that, my lord, they have incorporated this clause that there is the party, my lord, there is a provision for renewal. But your lordship will find nowhere in that agreement, my lord, it has been provided that 11 months, the 5 years locking period. Now they are telling for the first time that this is the locking period. Now the question is, my lord, a policy which has been sought to be, after all, my lord, this policy, my lord, I would say, my lord, this is not a notification, because this is a delegated legislation. Now the question is, my lord, when, my lord, this subordinate legislation, my lord, this type of legislation, my lord, executive order. Question is, my lord, that cannot, my lord, override, my lord, an agreement executed by the authority. The same authority has entered into a license agreement which provides a clause for renewal. The question is, when I have applied for renewal, my lord, they are being the authority, they have to, my lord, apply their mind, because you should not, my lord, one line cryptic order you will pass, because I have already, my lord, I have already invested a substantial amount of money. My lord, I am also running a cafeteria. It is a question of livelihood. Now, 11 months, my lord, when, my lord, before that, my lord, they already issued 3 eviction notice. That too, my lord, during the.
So what is the tender process over?
The question is.
Lordship, the tender process is over. Shop has been allotted to another person. My learned friend has annexed a document.
Yes,
He's fully aware of who has been given. No, a third party interest has been created, but nobody has been implemented.
Because, my lord,
now he's looking for an interim
because this gentleman, my lord, my lord, I am coming.
He's aware of the person.
Question is, my lord, whether
petition he has not implemented that person.
Question
Now,
is, my lord,
lordship, we have completed the auction. He is aware that, lordship, the policy says yes, 11-month leave-in license agreement can be renewed. It is up to 5 years. And then Lordship will, showed your Lordship page 43, where it was not only my learned friend's client, but there were several others who had exceeded the 5-year stay who were given this notice. And now they are under the cooling off period. A person has been already, he is to take charge from the 1st of December. Today we are on the 4th.
May I respond to what has fallen from my learned friend?
When is to be taken?
1st of December 2025.
But the question is,
his agreement, his
Not
life
vacated.
is till 30th of November. We completed the auction. He was to take over from the 1st. Now this is the situation.
but the question is,
The person is not implemented by
when one of the license agreement is subsisting, well, the question is whether my learned friend client can conduct a auction. First of all, and not allowing me to participate. But that was behind my back auction has been conducted. But I am not aware of any such auction because I came to know subsequently. But when I came up before this honorable court by way of a writ petition, it was ultimately it was affixed. By that time, auction has taken place. Now, my lord, a LOT, my lord, whose license.
That's why you cannot be allowed to participate because
My lord, that is a draconian, my lord. That cannot be. My lord, that violates my lord, Article 14.
So you're not challenged that.
But I have challenged here.
Where is
I auction I have
where
challenged.
is the prayer?
Well, kindly see, auction I have challenged. I sought for yes. Well, I am showing you.
Where is the prayer?
I am showing you lot. Auction I have challenged.
Where is that?
Yes, well, kindly come to the prayer portion. I said set aside the auction. Well, kindly
Not
come
auction. With regard to this
Policy,
guidelines which February.
guidelines are not challenged.
Guidelines of the February 2000.
No.
My lord, the guideline. Firstly, my lord, I have said that is I sought for leave pair A, pair B. My lord, I have said that the letter dated 6th November 2025, quashing of that letter, where my lord they have quoted the guideline. So in effect, my lord.
But you are not challenging the guideline.
And then, my lord, kindly see the prayer C. Issue a writ of mandamus quashing the impugned e-auction sale conducted by the respondent number.
If you're challenging the e-auction, you have to make a party to the persons who already been selected. You have given the name. I not made a party.
Well, I do not know his address, my lord. Let them provide. They have not provided me, my lord. How can, my lord, the difficulty is this, my lord. So far, my lord, that e-auction that took place during the subsistency of my license agreement. That license is very subsisting.
But the first as per the
But
submission, it is for the 1st December, not from before November. Not before December, because you are in 30th November.
There are two writ petitions. Initial writ petition was filed, my lord, challenging, my lord, when they say you vacate the shop room during the lease period, license period. My lord, what I am on, my lord, kindly, my lord, see the conduct of the authority. First of all, my lord, there was a prevailing license for 11 months. That license was continued. During that period, my lord, you conduct a auction, knowing fully well that the allotment is going to expire on 30th November 2025. You conduct the license, conduct the auction in the month of August. Question is, my lord, whether, my lord, during the subsistence of another license, when I am already a LOT, can you conduct a license in respect of a shop room when there's when the license is very much subsisting on that day?
He has been allowed.
And that too, my lord, without allowing me to participate. Kindly see Article 14 violation. My lord, I have invested a substantial amount of money. I am running but there cannot be any law which can debar a person from at least participating. You can give it to anybody. When, my lord, already there is a renewal clause is there, then, my lord, the renewal clause has got no meaning. Renewal clause, my lord, there is no restriction in the agreement that says that it will be subjected to 5 years only. It says that renewal clause can be given for 2 consecutive terms. 1 term and therefore another term. If they with an open eye, they enter into an agreement and later on, they take a different point and say, no, there is a policy, you cannot have it. So, my lord, I am joining issue. Firstly, my lord, the e-auction conducted during the subsistence of the license agreement. And also that too, my lord, the LOT was not allowed to participate. That is, my lord, that tantamounts to violation of Article 14. Because I am running the shop, I have been, my lord, in position, and there is no notice. Secondly, my lord, one after another eviction notice was served upon me, knowing fully well that my lease is very much subsisting. Now, I shall show to your lordship 2 so-called notice, my lord. Kindly come, my lord, what they have stated. What they have said, kindly see the total, my lord, the conduct and the first so-called notice will appear 17 May, my lord.
I will show you. My lord, I have not committed any default. I have paid rent up to date. My lord, kindly come to annexure P5, 21st June. Page
43.
page
Lordship.
44. Yes, internal page 29 by 44.
44.
44.
Achha.
Well, kindly see. That is the subsequent notice, 21st June. And the preceding page, your lordship will find the 17 May notice. Same verbatim, my lord, the same notice they have produced one after another, my lord. That time, my lord, my license was very much subsisting. Now, my lord, I am asking this question to myself. My lord, when the license was very much subsisting, and when, my lord, there is no default, how could the authority, my lord, invoke this type of clauses? If this is not arbitrary, my lord, and my lord, that too, when you are conducting auction, my lord, and your lordship, absolutely, my lord, what has fallen from, I alive to that I have not been made the auction purchaser a party. Well, lordship, kindly take note of the fact this auction has been conducted behind my back, and that was only surfaced, my lord, when I have filed the first writ petition. By that time, the auction has been conducted. That writ petition now has become impactuous since, my lord, 30th November has already expired. My lord, that has lost its force, spent its force. But the second writ petition, my lord, I have challenged the e-auction. Because I say, well, if your lordship, I can add him as a party, because this is a question of law. Because during without allowing, it's a question of violation of fund. You cannot, livelihood, my lord, cannot be deprived on the strength of a policy, my lord.
Yes, that's all.
Lordship, the bookstall that my learned friend was in charge of, I'm handing over the judgment, Lordship, where your Lordships have also held.
That there also, your lordship has provided me that.
There it was, yes. in
Rescind
that
order.
case,
And
the
thirdly, my lord, this is
petitioner
not a
was-
rescind order.
Lordship, in that case, the petitioner was within his period of.
Here also within period.
And here, now that period has gone.
No.
So there is a difference, and even Lordship did not allow him
File
to
the
extend.
present application.
No.
Challenge
Rescind order, directed lordship, directly pass a rescind order.
notice. Dated 6/11/2025, wherein the request of the petitioner for extension of period of the lease agreement is rejected. The petitioner says that initially on 1st of June 2019, the lease agreement was executed between the petitioner and the respondent authorities with respect of
খুব ভালো বললেন।
respect of shop number 9, building number P-19, inverted comma cafeteria, near SBI, E-lobby, BMC. Full stop. As per the set, the tenure of the said lease agreement was for a period of, initially it was
for a period of 11 months.
For till 30th April 2020. 30th April 2020.
Lordship, the first one was 1919, and then the last one was 25, January
Subsequently,
2025.
Again on 1st January 2025, a rent
Till
agreement
30th.
was entered between the parties, wherein the lease period of the petitioner was extended till 30th November 2025. Fully. In the lease agreement, there is a clause of renewal option. Accordingly, the petitioner before the expiry of the lease period has made a representation to the authority for consideration of the case of the petitioner for renewal of the lease period. But the authority have rejected the prayer and passed the impugned order. Full. Then a counsel for the petitioner submits that earlier also, during the subsistence of the lease period, the authorities have issued a notice relying upon the policy dated 7th of February 2018, 7th February 2018, directing the petitioner to vacate the premises by 31st of July 2020. Again, on 21st of June 2025, the respondents have again issued the notice for eviction. Police. In the meantime, the respondent authorities also conducted the tender process, and the shop in question has also the subject of the tender, and another person has been selected for allotment of the said cafeteria. Counsel for the petitioner submit that the policy dated 7th February 2018 was with the respondent authorities, but have not taken into consideration of the said policy, and have entered into the lease agreement initial on 1st of June 2019 and subsequent on 1st of January 2025. Thus, in the mid of the lease period, the respondent authority cannot take the benefit of the policy which was existence at the time of entering into the lease agreement in the 2019 and 2020. Counsel for the petitioner further alleged that the petitioner has also not given an opportunity to participate in the said tender.
And my lord, also one thing, my lord, no opportunity of hearing was given to me while deciding my application for renewal.
Though the petitioner has made representation and the authorities have rejected the request of the petitioner, but no opportunity of hearing was given to the petitioner before passing
Lordship, we are not, without affidavits,
before
nothing is
issuing
admitted.
before issuing
We're not
the
using affidavits.
notice of eviction, a rejection of the before issuance of rejection of the impugned notice. Pull it. Learned counsel appearing for the respondents submit that time to time the lease agreement of the petition was extended. Lastly, on 1st of January 2025, the lease agreement was extended for a period of 11 months, which expires on 30 November 2025. Before the expiry of the lease agreement, the petitioner notices were issued to the petitioner directing the petitioners to vacate the premises, but the petitioner has not vacated the premises. As the lease period was continuing till up till 30th November 2025, accordingly, in the meantime, the respondents have started the tender process, and tender process was completed. And the third party have been selected for allotment of the cafeteria, but the petitioner has not made the said third party as party respondent, though the third party interest had been created. Learned counsel for the respondent further submits that though in the agreement it is mentioned with though in the agreement dated 1st of January 2025 there is a provision of a renewal option, but it is for the license, it is for the authority to consider whether it can be extended or not. He further submit that as per the policy of 2018, the allotment shall be subject to 5 years, and as per the Government of India Ministry of Defence letter dated 25th of September 2024, the existing licensee of entitled category may be allowed to participate in the third auction proceeding without considering the consideration of the cooling off period. Accordingly, the petitioner is continuing with the premises in question since 2019. Thus, the petitioner is not entitled to participate in the tender process. Accordingly, petitioners are not considered to be allowed the petitioner to participate in the tender. Had the learned counsel for the respective parties peruse the materials on review. Admittedly, since the year 2019, the petitioner is running the cafeteria. The last agreement was entered on 1st of January 2025, which is up till 30th November 2025. As per the renewal option, the petitioner has made a representation to the authority for consideration of the request for renewal for further period. But the authorities have taken considering the
Lord, item number 20, Lord.
The policy.
I am appearing for the petitioners.
Considering the policy.
What are the changes?
Considering the policy have found that the petition is not entitled to further extension. Accordingly, tender process was started and party have been selected. And in the tender process, one person has been selected for allotment of the said capital. The respondents have considered the representation of the petitioner and found that the petitioner is not entitled to get the extension. Accordingly, the same was communicated. Considering the above, this court find that there is no illegality in the impugn communication, wherein the respondent authorities have informed the petitioner with regard to rejection of his prayer for extension of the interim. Thus, the writ petition is dismissed. No order as per law.
Sir, urgent zero, sir.
Huh?
Urgent 35 movie, madam. Urgent 35.
What supplementary? File आया?
My Lord,
My lord, I appear for the bank, my lord.
Lord, item number 20, Lord, I appear for the petitioners.
Which one?
Item number 20.
20. 20
Lord,
is not called.
It has wrongly, my Lord.
20 is not called, sir.
My lord, I appear for bank, my lord. Miss.
Lord, it has wrongly appeared, my Lord. Kindly, my Lord, release the matter and go before the appropriate bench. Item number 20.
Come tomorrow, we'll see to that. Yes.
It has wrongly appeared.
Okay, I will see.
My lord, Miss Sonioja is appearing at the first half. She was present, my lord. Due to some family difficulty, she has to leave court, my lord. Miss Sonioja is appearing in this matter for ban. And kindly fix tomorrow to be mentioned, my lord. Grave urgency.
Interim order, what is about the interim?
Tomorrow to be mentioned. Till that time, we will not take steps.
To be mentioned.
Till tomorrow to be mentioned, my lord.
Why?
My lord, there is an urgency. Her mother-in-law will be operated today.
Correct, no problem. So I am extending the interim order. Come.
No, my lord, there is some difficulty.
You are taking the both laddu in the both hands.
Tomorrow to be mentioned, my lord, at the first half, number 1 item, my lord, at the top.
My lord, I am appealing for Reserve Bank.
As per the submission made by the counsel for the petitioner, counsel for the respondent, what respondent number?
2 and 3.
Respondent number 2 and 3. Case is adjourned. Let the matter appear on 10th of December 2025.
Your Lordship is extending.
10th of December 2025. In the meantime, where is the interim order?
Yes, my lord. This is the. This.
In the meantime, the court.
And this is the order which has now been served, my lord.
In the meantime, the court hope and trust that the authority will not take any steps under the Surface Act 2000.
10.
Could it be on the 11th instead of 10th?
10th. 11th.
11th. I'm great.
11th under the heading. Let the matter appear on 11th under the heading urgent motion. Urgent motion.
I'm so grateful.
देखो रिलीज को आने दो देखेंगे ना surfaces is not applicable बाद में there that's why the court release.
But this is the order by which it was released, holding it's not a surface.
It is there. It is there.
Grateful.
ওই তো দিয়েছি কোথায় দিলি ওই তো তুই বলছিস তো
Yes.
Mentioning a matter upon compelling circumstances. Now, this is a read petition that was filed in the month of May. In the month of June, my lord, we have taken out an application for contempt. Now, my lord, that was pending. In the month of August and September, there were orders from this honorable court, my lord, that both the contempt and the read petition should be heard out together so that a comprehensive order is passed. Now, my lord, thereafter, my lord, in the month of November, it appears, my lord, there is a change of determination, and so the contempt is appearing in one court. It was taken up day before yesterday, my lord, and the writ petition, my lord's determination. But and in the returnable date, the writ petition obviously did not appear. So I am mentioning this upon notice. If it can be fixed tomorrow on Monday on day, as to be mentioned, if my lord wants to, but it's entirely for my lord. But we wanted, my lord, a hearing. If it is before this honorable court or before any other court, my lord, it's entirely my lord's discretion and prerogative. But our prayer is, my lord, if it is fixed on Monday as to be mentioned or tomorrow, whatever date, we can make submission so a decision can be taken, my lord.
Monday to be mentioned.
Monday, deeply available.
Inform the other side.
Yeah, I have given notice.
May I be permitted to mention a matter for extension of interim order? It's
This
expiring next Friday, not.
This matter.
No, some other matter.
It's not listed.
No, it's not listed.
When the interim or when it go?
25 July, my lord, the interim order was passed by the predecessor bench, my lord. It's expiring next Friday.
Next Friday.
Upon notice,
Friday means
12th.
12th. 11th को रख दो to the
Well, may I
extension of
mention-
interim order.
Well, may I mention item number 2, Mr. Advocate General is also here. He is for the state. Today, the item number 1 will take some time. And last order, Lordship gave them a last chance to give their report long back, but then they gave it yesterday. So, Lordship, can you keep it Monday week? We shall give our rejoinder, if any, before that. Okay, opposition in the form of report.
Court application कब रहता?
Tuesday, then Tuesday week if it's possible. Though Vaidis is under challenge, but I will not take more than half an hour maximum.
Filing the report.
State and WPATC both.
The item number 2, huh? Learned Advocate General has filed the report. Let after serving the copy to Learned Counsel for the petitioner, let the same be kept with the record. Counsel for the petitioner prays for you will take exception.
By Monday week, I shall give the exception I'll give the date, my lord.
Filed by Monday, 8th of December 2025 after serving the copy to the Learned Counsel for the
by December 5th.
List the matter on 9th of December.
Lordship 16th. 15th by 15th, because today is the 4th. By 15th, I shall give my exception, and 16th kindly fix it.
By 15th, huh? Let the matter appear on 16th.
I filed 2 reports.
Interim, yes, 2 reports. Learned Advocate General filed 2 reports after serving the copy.
And the interim order to continue.
Interim order is extended till 19th of December 2025 or until further order, whichever is.
I'm grateful.
My lord, item 53 is also a similar matter in the original side list. My lord, item 53 is also a similar matter in the original side list, my lord. The respondents have not yet filed a reply.
What 53? What you want?
My lord, similar matter challenge to the same act. My lord, I am seeking same directions, my lord, if may be passed in my matter too.
Report filed?
No, my lord, they have not filed a report. The order was passed on 13th August, my lord.
Okay. So if not filed, what can be done? Let it be remain in the list. Yes.
Your Lordship, may I have your kind leave to mention for extension of interim order, Lordship? I'm mentioning upon notice. The
When?
interim order is expiring on 12th of December, Your Lordship.
Fix your Garago to be mentioned.
Grateful, Your Lordship.
Garago to be mentioned, here interim order. Yes, call the list.
Lordship, this is for the examination of the defendant. Yes.
I got the plaintiff.
So, just one housekeeping matter, my lord. For yesterday's deposition, my lord, there are some typographical errors. So, my lords, I've not been able to indicate it. On the next date, may I come with the?
You can give the other call.
Yes, my lords, we'll also provide them with the call.
Ramesh Kumar Kejriwal.
I was waiting for item number 3, Milord. I do not know whether the.
I think other matter will not be taken. It will take time.
Yes.
It will continue.
May I have the indulgence to pray before your lordship, Milord, in the next day, Milord, so the matter can be, it's an allegation against of a sexual harassment, Milord, under the act. Mrs. Mukherjee.
Item number
3, Milord. If your lordship.
No, next Tuesday it will come
I'm
up.
exhibited. I'm sorry for the interruption. All other matter released.
All matter released.
Grateful lordship.
Yes.
Do you recall that on the last occasion you had mentioned about proceedings in the Bangshal court?
Yes, sir. Yes, I recall.
I am showing you a document which is appearing at page 2095, volume 7 of the judge's brief, which has been marked as Exhibit Z. Can you please tell my lords what this document is?
जो 138B केस हुआ था, फादर का डिपोजिशन है ये, बाबूजी का वहाँ कोर्ट में जो बोले वो सब है.
This is a deposition of my father. Recorded in the case under section 138 of the NI Act.
Can you tell my lords what did your father say in the deposition?
Sir,
it is exhibited document.
Milords, I see that from the records, Milords, it's been marked as an exhibit.
No, not necessary.
इसमें एक तो
Yes, Milords, but I'm purity of records, Milord, I had to indicate, but whatever your lordships.
इसमें सर ये दो तीन इम्पोर्टेंट बात है जो हम बताना चाहते हैं. पहले पहला तो ये है, जैसे कोर्ट पूछा कि भाई डू यू हैव लाइबिलिटी टुवर्ड्स एसके इन्वेस्टमेंट. जिसने 138B केस किया था,
One 138 of NI Act. Yes.
तो उन्होंने कहा था नहीं, हम लोग की हमारी कोई लाइबिलिटी नहीं है. फिर कोर्ट ने पूछा था कि क्या आपने चेक इशू किया. तो फादर ने कहा नहीं, हमने कोई चेक इशू नहीं किया. फादर ने ये भी कहा कि 99 से हम बिजनेस नहीं देखते हैं, 1999 से हम काम नहीं देखते हैं.
He is not looking after the business since 1999.
लास्ट में था कि आप कोई डिफेंस विटनेस खड़ा करेंगे, तो बाबूजी बोले कि हाँ हम लोग डिफेंस विटनेस देंगे. अपनी इस बात को सपोर्ट करने के लिए। बाबूजी सर उसमें ये भी बोले थे सर कि 99 से हम काम नहीं देख रहे हैं क्योंकि मेरी वाइफ इल है, उसी इलनेस में हम बहुत ज्यादा पजल्ड हैं, ऐसा बोले थे सर।
Yes.
I'm showing you another document, which is DD19 at DD19 at volume 8, page 2155 to 2193 of the judge's brief. Can you tell my lords what this document is?
सर ये जो 138B का केस हुआ था उसका ये फाइनल जजमेंट है। बाय एसके इन्वेस्टमेंट, और ये जजमेंट का डेट है 16 में 2011। इसमें सर हम दो इम्पोर्टेंट पॉइंट है सर, इसमें हम बोलना चाहते हैं सर। यहाँ को दिख नहीं रहा है पर हम बताते हैं सर। एक तो है कि बाबूजी को कोर्ट छोड़ दिया क्योंकि उन्होंने लाइबिलिटी एडमिट कर लिया है और पेमेंट कर दिया है।
Paid
पेड।
the amount.
दूसरा सर वो हमरे लिए बोला कि नहीं एक्विटेड, ये लास्ट में है, एक्यूज्ड पर्सन इज फाउंड नॉट गिल्टी।
Correct that. वो ठीक और आगे चाहिए
और
आपको?
हमको छोड़ दिया कि नहीं,
आपको भी छोड़ दिया.
हमको भी छोड़ दिया कि हम तो फाइट किए थे,
The court
उनका
has also
लाइबिलिटी था नहीं।
acquitted me from the said case.
मैंने उनको पैसा वो बोले हम दिए तब छोड़ दिया, हमको ऐसे ही छोड़ दिया मतलब।
I have been acquitted without payment of money, but the father has paid the check amount to the complainant.
विच जो फादर सही किए थे सर 24
Against the
लाख
check, against the amount, against the check in which the father has signed.
24 lakhs का चेक था सर वो, और हमने सही किया था 40 लाख का दो चेक सर।
It was about 24 lakhs, and the check which having my signature, having the amount of rupees 40 lakhs
40
each.
lakhs each.
This entire litigation, which started in 2002 and ended in 2011, who was funding the expenses for the litigation?
सर इसमें केस तो किया था एसके इन्वेस्टमेंट ने, तो एसके इन्वेस्टमेंट का जो खर्चा था वो महज देता था सर। माय यंगर ब्रदर। और हम लोग जो एक्यूज थे, मैंने फादर और हम, महेश को तो वो नहीं किया था कुछ, हम और महेश को, हम और बाबूजी को का केस का हम पैसा देते थे। रमेश।
As regard the expenses of myself and my father, we have borne these said expenses But Mahesh, my brother Mahesh has not done any expenditure with regard to our expenses of the case.
But he will give money to SK Investment for his expenses.
He managed.
महेश मैंने एसके इन्वेस्टमेंट को केस करने के लिए पैसा महेश देता था सर.
Got it, right? It.
हाँ.
On what basis do you say that Mahesh used to pay on behalf of SK Investments?
सर इसका 2-3 कारण है. सर सबसे पहला तो वो कोर्ट में ही महेश को हम देखते थे, वो वकील को पैसा देता था. महेश उसका श्रवण केजरीवाल के वकील को कैश पैसा. दूसरा क्या है सर, एसके इन्वेस्टमेंट के पास में कोई काम नहीं था सर. ये तो उनका यदि आप 3-4 साल का उस समय का कोई भी बैलेंस शीट काम देखेंगे तो नील, कोई काम ही नहीं. चेक इशू करने के अलावा मैंने ये चेक हम लोग से जो किया उसके अलावा कोई काम नहीं. नो बिजनेस. और सर ये उसी पीरियड में एसके इन्वेस्टमेंट मैंने श्रवण केजरीवाल वाज डायरेक्टर इन महेश का कंपनी, वहीं से वो अपना लेन देन करता था या चलाता था घर. और कंपनी का नाम था सर और उस कंपनी का नाम था, महेश की कंपनी का नाम था जिसमें श्रवण केजरीवाल डायरेक्टर थे, पारिजात व्यापार.
नहीं, कंटेंट खाली WP.
पारिजात व्यापार प्राइवेट लिमिटेड.
How would you describe your relationship with Mahesh and your father during this litigation? Malaj, may I just clarify? During the litigation that started in 2002 and ended in 2011.
सर ये 2002 में जब केस स्टार्ट हुआ, जो महेश ने जब केस किया तो सॉरी श्रवण केजरीवाल ने जब केस किया हम और बाबूजी साथ में सलाह करके इस केस को, माने वो हम लोग साथ में थे तो बहुत सलाह करके इस केस को लड़ते थे.
With each other.
और महेश के अगेंस्ट में ये केस नहीं परसू हो रहा था. महेश बाहर रह करके हम लोग को डराने का ही काम करता था कि मैंने क्या क्या खराब हो सकता है, क्या क्या नुकसान हो सकता है हम लोग का, कॉन्सिक्वेंसेस क्या क्या हो सकता है हम लोग को. तो महेश से तो मेरा सर 96 से रिलेशन खराब होने लगा था. 96 से पहले से ही मतलब. और बाबूजी से सर हमारा ठीक था, हम तो उस घर में थे 2007 तक, तो जब तक हम थे तब तक बहुत अच्छा रिलेशन था सर हमारा. जॉइंट होम था हम लोग का सर, हम लोग का जॉइंट होम. फिर सर 2007 के बाद में हम घर से, हमको निकाल दिया था 2007 के बाद में. और इधर माँ का भी डेथ हो गया था 2004 में। दो हजार सात के बाद में बस सिचुएशन और खराब होने ही लगा मतलब।
Yes, next.
You mentioned you had left the house in 2007. Where did you stay after that?
सर हम लोग 2007 में हम और हमारे चाचा जी हम लोग दोनों हम निकले तो चाचा जी बोले हम भी नहीं रहेंगे यहाँ पर अकेले, वो भी हमारे साथ निकल गए, जबकि घर हम लोग का
कहाँ रहते थे आपको बताइए।
अरे हाँ सर, हाँ हम लोग रहते थे सर भाड़ा का एक जगह में खिदिरपुर में, आइडियल टावर। आइडियल टावर खिदिरपुर में है सर। अचानक वहाँ हम लोग को जाना पड़ा तो वही।
Yes, next.
Why did you leave your residence in 2007? Why did you leave your earlier residence in 2007?
सर ये 2004 में मेरी मदर का डेथ हो गया था। और वो महज उनका बात सुनता था, तो फिर सर ये 2005 से, फ्रॉम 2005 महज घर में बहुत हल्ला उल्ला करता था। और सर वो मैंने उसका था कि तुम फाउंड्री में बहुत बड़ा नुकसान लगा दिया, पूरा घर ही उसमें बर्बाद हो रहा है, ये है वो है, ऐसा करता था। तो सर पहले तो माँ उसको रोक देती थी, बट सर फिर बाबूजी को हम बोले देखिए कैसे हल्ला कर रहा है, सुबह शाम ऐसे कर रहा है ये, तो फिर बाबूजी भी धीरे धीरे साइलेंट होने लगे, मैंने कुछ बोलते नहीं थे मतलब मैं इसको। फिर एक दिन सर महेश, मैंने हमने रूम का दरवाजा ही तोड़ दिया। मैंने सुबह का टाइम था, रविवार का था कोई दिन, तो मैंने मेरी वाइफ थी रूम में, तो हल्ला उल्ला करके दरवाजा ही तोड़ दिया रूम का। सर हम लोग दूसरे दिन ही, फिर हम लोग का तो घर था नहीं कोई, हम लोग भाड़ा में मैंने मंडे को ही अपना रूम लॉक करके हम लोग चले गए। बाबूजी भी कुछ बोल नहीं रहे थे, तो हम थे कि और फिर उस दिन वो थाना वाला भी हम लोग को बुलाया कि आप लोग क्या झमेला करते हैं, इतना अच्छा आदमी होकर के ये करते हैं वो करते हैं, तो बड़ा प्रॉब्लम हुआ हम लोग को। बालीगंज थाना में।
Yes.
Did you, after leaving your earlier residence, what was your relationship with your father?
सर मेरे पिताजी के संग नाता ठीक था सर, और इनफैक्ट हम सर फिर हम 2007 के बाद में हम लोग जुलाई अगस्त में कब निकले थे, तो दिवाली आया उसके बाद में, तो हम दिवाली में होली में ऐसे मिलने जाते थे उनसे। और उनसे पता है, तो वो हम जब मिलने जाते थे सर, तो वो मैंने ऐसे नहीं कि मुंह उठा के चले गए, मैंने गेट पे हमको बताना पड़ता था, रोकता था वो लोग हमको। और
We have to take permission from the chief.
मैं से वो फिर हमको गेट पे बैठाता था वो, मैं हमको वहां पर गेट में, मेन गेट में घुस के बैठा देता था, वेट करो। और फिर थोड़ा देर बाद में शायद बाबूजी तैयार होते हैं, पता नहीं क्या, फिर वो बाद में ड्राइंग रूम में हम लोग को बुला के ऐसे बात करने देता था। और सर सब बात करते थे तो कोई ना कोई उसकी वाइफ या ऐसे घूमते रहते थे, देखते रहते कि हम लोग कुछ बस समझा, पता नहीं हम लोग क्या कर देंगे।
Yes.
At the time of these meetings that you are referring to, what would be the demeanor of your father? Let me just make a correction. What would be the behavior of your father?
वो तो ऐसे आशीर्वाद ही देते थे सर, पर ऐसे डरे हुए रहते थे बहुत ज्यादा। क्योंकि उनके पास काम था नहीं, माँ भी थी नहीं। और वो उनका जो रहने का या दवाई का या जो भी है, वो घर में थे तो महेश ही देखता था। तो वो थोड़ा सा मैंने उनको मैंने इस बात का बहुत तकलीफ होता था। वो हम लोग का जो कॉर्नर का रूम था सर, उसी में शुरू से बाबूजी और मम्मी वहीं रहते थे। उसमें बरामदा भी था। तो मैं और बगल के रूम में मेरा रूम था सर। तो फिर वो महेश क्या किया, वो बाबूजी को उस रूम से हटा करके मेरा रूम को और छोटा कर दिया, उसमें शिफ्ट कर दिया उनको। तो क्या है सर, वो बाबूजी और वो लोग हमेशा ही बैठते थे बरामदा में, घास वास रहता था वहां पर में। तो वो लगता था पेन एकदम उनका आंख से ही लगता था, बात से उतना बोलते नहीं थे। पर वो उसमें उनका शुरू से ही थे हम लोग सर, जब से उस घर में 86 से रहते थे। बाबूजी वहीं रहते थे सर, तो उस रूम को भी वो चेंज कर दिया उनका। सर वो मैंने बाबूजी बोले कि कोई वास्तु वाला बोला ये साउथ वेस्ट में रूम था सर, ये एकदम साउथ वेस्ट में। तो बोला कि मालिक को साउथ वेस्ट में रहना चाहिए। तो बाबूजी को वहां से हटा के महेश वहां आ गया सर, साउथ वेस्ट। तो हम लोग तो हेल्पलेस थे, कुछ कर नहीं पाते थे।
How long were these meetings for, were with your father?
सर ये हम लोग जब जाते थे आधा घंटा करीब बैठते थे। तो असल में हम लोग बोलते थे, बाबूजी चुप रहते थे। थोड़ा सा वो रहते थे, देखते कोई नहीं तब कुछ बोलते थे, हाँ तुम लोग ठीक होना, ये है वो ऐसा करके, जब देखते कोई नहीं आसपास में। और सर उस समय तो बच्चों का शादी भी नहीं हुआ था, तो पूछते थे क्या कर रहे हो, कैसे हो रहा है, कैसे रहते हो। तो बाद में तो सर ऐसा हुआ कि हमको बंद ही कर दिया महेश। और नीचे गेट मैंने वो दरवान को मना कर दिया कि हम जा नहीं सकते हैं। तो वो तो कोई हम लोग को बोला कि आधा कर तो तुम लोग का थाना में केस करो जाओ। तो हम लोग वो सब झमेला में गया नहीं सर फिर। somebody advised us, वकील लोग, मैंने वकील लोग
Somebody has advised us to go to the police station and make report to meet the father, but we are not. We thought that it is not fit to go to the police station. We not made any report.
Till when did these visits continue?
सर ये हम लोग घर छोड़ने के 2-3 साल तक चला सर ये 2 साल 3 साल तक चला सर ये
Yes, next.
How did you keep in touch with your father thereafter? ऐसे संबंध में
सर ये उनसे बस ये क्या कि एक तो राय बहू है हम लोग के यहाँ सुब्रतो राय बहू वो हम लोग को वो योगा कराते हैं 35 साल 40 साल से है हम लोग के साथ में तो वो हम तो इधर आ गए तो वो बाबूजी को वो जाते थे बाबूजी को कराने के लिए मैं एक्सरसाइज ये सब कराने के लिए सब करने के लिए
He used to visit my father to see the father.
और हमारे पास भी आते थे
And he also used to come our house.
वो अभी भी आते हैं हमारे पास में तो उनसे हमको पता चलता था बाबूजी के बारे में तो वो हमको बोलते थे कि ऐसे पैजामा में ही रहते थे बाबूजी ऐसे गंदा पैजामा में कोई बाहर का आदमी आता है तो वो उनको रूम में ले आके कपड़ा वपड़ा पहना के बैठा देता था कि हाँ देखो सब ठीक है
Yes.
Can you tell this honorable court what was your father's physical health till you were residing in the earlier residence? Physical health.
हाँ ठीक है सर इनका बाबूजी का शुरू से हेल्थ अच्छा था सर एकदम केवल उनको केवल हार्ट का एक प्रॉब्लम रहता था हम उनको एक डॉक्टर डालमिया थे एस डालमिया डॉक्टर एस डालमिया वो और हमारे चाचा जी डॉक्टर वीके केजरीवाल माने हिज यंगर ब्रदर तो वो लोग दोनों मिलके उनको देखते थे और बाबूजी का भी कुछ होने से अपने छोटे भाई चाचा जी से कंसल्ट करके अपना करते थे कि हमको अब क्या करना है वो क्या करना है करके डॉक्टर विजय मैंने उनका मेन हार्ट का ही रहता था तो वो डॉक्टर डालमिया हार्ट स्पेशलिस्ट हैं सर वो बाबूजी को और मम्मी को दोनों को ही देखते थे सर वो और वो बस वो हम ही जाते थे बाबूजी को लेकर के डॉक्टर के पास पार्क स्ट्रीट के बगल में चेम्बर था उनका जीके स्पोर्ट्स के बगल का बिल्डिंग में जीके स्पोर्ट्स का है उसके बगल में एक बिल्डिंग है जब तक उस घर में थे हम बालीगंज का हाउस में
Yes, next.
What was your father's mental health during up until 2007, that is when you were living in your earlier residence?
सर बाबूजी का तो 1999 के बाद से फ्रॉम 1999 और हम लोग 96 में हम लोग का पार्टीशन हुआ सर टेम्पररी फैमिली सेटलमेंट हुआ 96 में हम कारखाना का काम देख रहे थे, महेश मशीन
तो
का
आप
काम।
बता दिए, आप सीधा बताइए कि आपका फादर का मेंटल कंडीशन कैसा था।
सर वो बाबूजी का वो 1999 के बाद से धीरे धीरे वो माने शांत भी होने लगे, डिस्टर्ब भी रहने लगे। इधर माँ का भी तकलीफ था, और जो अल्टीमेटली पास अवे हो गई 2004 में। काम भी जो छोड़ दिए। हाँ हाँ। और वो सर पैसा हाथ में था नहीं, तो कॉन्फिडेंस भी एकदम खत्म सा हो गया।
Yes, next.
After 2007, how would you describe your father's physical health when you used to meet him?
सर हम तो हर मीटिंग में, हर मुलाकात में उनको देखते थे पहले से और कमजोर, या पहले से गोइंग डाउन, माने खराब होना।
Yes.
How was your same question, mental? How was your father's mental health condition when you used to visit him after 2007?
सब पूरे इनडिसिसिव से हो गए थे सर, इनडिसिसिव। जैसे जैसे उनको बोलते कि महेश ऐसा कर रहा है, तो वो बोलते कि वो कुछ बोल नहीं पाते उसमें, अपना कुछ भी इनपुट नहीं देते थे, चुप मतलब। ब- और बाद में तो सर वो उनको हार्ट अटैक भी हुआ फिर। तो हम अपोलो हॉस्पिटल में गए उनसे मिलने के लिए। तो आई वॉज शॉक्ड कि वो बोल भी नहीं सकते हैं, और वो केवल हंसते रहते थे, माने हम कुछ बोलने से उसका कोई जवाब नहीं।
Could not able to speak. बोल नहीं सकते थे।
मैंने कुछ बोलने से कि अच्छा खराब कुछ भी बोले तो जैसे लगता है हंस रहे हैं, बस ठीक है। मैंने समझ में नहीं आ रहा है उनको क्या हम बोल रहे हैं।
Yes, next.
The two doctors, remember, there's he's already stipulated the name of the doctor, so on that. While consulting Dr. S.H. Dalmia and Dr. V.K. Kejriwal, who would accompany your father for these consultation visits?
सर चाचा जी से तो घर में होता था, और डालमिया जी के यहाँ हम जाते थे सर, डॉक्टर डालमिया के हम जाते थे। डॉक्टर डालमिया सर, ये एसएस डालमिया है सर।
SS डाल।
2 बार ऐसा शायद श्याम सुंदर होगा शायद।
Yes, next.
Can you name other doctors who were attending your grandfather's health?
Grandfather.
Sorry, your father's health. Sorry.
नहीं, और कोई डॉक्टर नहीं थे सर।
No other doctor.
You have mentioned that your father had heart ailments. Where did he seek treatment for such ailments? Seek treatment.
सर 2007 तक तो हम जैसे आपको बताया डॉक्टर डालमिया ही देखते थे। उसके बाद का सर हमको वैसे नहीं मालूम, बट अपोलो में हम जरूर जाके उनको देखे थे, अपोलो हॉस्पिटल में सॉल्ट लेक में जो है, तो वहां पर वहीं का कोई डॉक्टर था, आर्या ना कौन, वो देख रहा था सर।
Yes, next.
Were you involved in any medical decision with respect to your father's health after leaving your residence in 2007?
नहीं, मेरा सर कोई रोल नहीं था, हमसे कोई रोल नहीं था मेरा सर, मेरा कुछ वो नहीं।
Yes.
Why did you not participate in your father's, in decisions pertaining to your father's health?
सर वो बाबूजी तो पूरे महेश के कंट्रोल में चले गए थे ना 2007 के बाद में ही। हमको और हमको मिलने भी नहीं देता था। हम लोग का उस समय सर ऑफिस था 12A नेताजी सुभाष रोड में। हाँ, तो महेश का ऑफिस था रूम नंबर 12 और हमारा था रूम नंबर 2। हाँ, तो सर बहुत कभी याद हम नीचे पार्किंग में बाबूजी को देखते थे, तब धोखा लेते थे, कभी बहुत रेयरली। हाँ, पार्किंग में गाड़ी के लिए वेट कर रहे हैं, कुछ हो रहा है तो हम खड़े हो गए, बहुत रेयरली कभी होता था, तो उनको बस घर तो जा नहीं पाते थे ना, तो वहीं पर उनको हाथ जोड़ लेते थे। मैंने
I used to see my father at the parking space when my father come to board the vehicle to going out.
वेरी रेयरली जब आते थे वो सर। हाँ हाँ, ठीक है।
Yes.
How many times did you visit your father in the hospital?
सर एक बार तो हम गए थे अपोलो में, तो जब उनको हार्ट अटैक हुआ था, हार्ट
When?
1 या 2 दिन गए थे, 2 दिन शायद गए थे हम, तो हम और उसके कुछ दिन बाद ही हम बॉम्बे गए सर। वो उनका ब्रिज कैंडी में पाँव का इलाज हुआ था, मैंने नी रिप्लेसमेंट हुआ था उस समय, पहले आगे बोल रहा हूँ। तो पर उस समय तक बस उनका बस वो क्या कि बोलना और समझना होता है ना, कि हम क्या बोल रहे हैं, जवाब तो कोई दे ही नहीं सकते थे, लिख भी नहीं सकते थे वो। तो फिर वो
Yes, next.
Who was paying for these medical? Let's please scratch that. May I just change the question? What were the sources of income of your father from 1999 onwards?
काम तो कोई था नहीं हम लोग के पास में उस समय, तो वो उनके पास उनके पास में शेयर्स था, शेयर होता है ना, शेयर्स, वो सब महेश अपने नाम में ट्रांसफर करा लिया था सर। और वो कोई बस महेश जो देता था या उसी के ऊपर चलता था, मतलब सर।
That I would be moving into another topic, Milad. May I just pray that may I come back? Milad.
How much time you will take further?
Milad, there are 2-3 issues left, Milad. I also have 2 seniors, Milad, above me. Milad, they would probably want to do on that issue. I'm praying, my lord, for.
Yes.
But after the group 9 matters the whole day, storytelling is nice.
Defendant's witness is present. Examination chief is started, but due to paucity of time, chief could not be completed. But chief is deferred. Let the matter appear. Date है क्या? जनवरी क्या था? 3:30.
दो दिन दिए देवे ना.
7 January.
My lord, if your lordships permit, my lord, may it be in the 3rd week of January, my lord. I'm in some difficulty.
When?
My lords, in the 3rd week of January, my lord, week starting 19th, if your lordships will permit.
19 January.
The week starting 19th, my lord.
19th and 20th January at 3:30.
No, 3.
19 नहीं है, मंगल को रहता है ना कोर्ट एप्लीकेशन है. 19 and 21st.
19th and 21st.
19 and 21st.
Yes. Time. My lord, would your lordships be pleased to fix a time?
3:30.
3:30. 19th and 21st. Okay. No problem. Waiting for no issues.
कुछ नहीं ना.
ये तो आगे उठे.